item number 1.
I beg to, Lordship, I beg to.
For reasons mentioned in the judgment, this writ petition is dismissed.
Delivery of order item 42 and 43.
My lord.
Two substantial
Much obliged.
Two substantial questions of law are formulated. Records are called for and next date of hearing is fixed on 19th of March. During the pendency of the connected regular second appeal, the proceeding of the execution of title execution case number 5/2025 is stayed.
Mention if it
May I please, Your Lordship, with consent of the other side, I beg to mention item number 15 of today's list, Your Lordship. In this matter, our senior counsel, Mr. R. Sharma, is appearing and he's out of station.
What is your name?
I'm P. Fukan, Lordship.
For the petitioner,
Yes, Your Lordship.
you have informed the other side.
Yes, Your Lordship.
Heard Ms. P. Fukan, learned counsel for the petitioner, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. She submits that she has informed learned counsel for the respondent regarding her prayer for adjournment,
No.
who does not have any objection to this thing. Hence, the prayer is allowed. Let this matter be listed.
On Monday, Lordship. Monday, this Monday.
Let me on Wednesday, madam.
Lordship.
Is there any difficulty on?
4th of February.
Both of them. Lordship, there's also an interim order. The same may
The
be.
interim order shall continue till next day.
Oblige, Your Lordship.
May I please, Your Lordship? Your Lordship, I beg to mention item number 13 and 14, Your Lordship. We have taken consent from the other side. The matter may be fixed on February 27, Your Lordship.
You
We
are,
have for respondent number 1, Your Lordship.
what is your name?
A. Kakoti, on behalf of A. Kakoti, Your Lordship.
Heard Miss, what is your name?
J. Rahman, Your Lordship.
J.
Rahman.
J. Rahman, learned counsel appearing on behalf of Mr. A. Kakoti. Prays for an adjournment. You have informed the other side.
Yes, sir.
What is your name?
Your Lordship, interim order may be granted.
What is your name?
B. Thakuria.
Her-
Item number 13.
In item number 14, P. Gogol.
Also heard Miss B. Thakuria in CRPA IO 397, as well as learned counsel for the petitioner in CRPA IO 397, as well as Mr. P. Gogoi, learned counsel for the petitioner in CRPA IO 395/2024, who does not oppose the prayer for adjournment. Hence, the prayer is allowed. Let this matter be listed on 11th of February.
27th of February, Your Lordship.
No, 11th of February.
Lordship, see, my senior will be out of station on that day, Lordship. Let it be after 15, Lordship.
20.
27th of February.
Highly obliged.
So interim order.
The interim order shall continue.
May I please, Your Lordship, I beg to mention item number 26. We have required more time to arranging the document.
You are for?
A. Soikia, Anjita Soikia.
You have informed the other side.
Yes. We have informed.
Heard Miss A. Soikia, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. She submits that she has informed learned counsel for the other side, who does not have any objection to her prayer. Hence, the prayer is allowed. Let this matter be listed. On
Lordship, maybe please give 2 weeks time, 2 weeks,
13,
after 2 weeks.
25th of February.
Bless Your Lordship.
May it please, Your Lordship, I beg to mention item number 32. Lordship, kindly pass this matter for this day, as my senior is having some personal difficulties.
You have informed the other side.
Lordship, I am for the respondent.
Heard Miss, what is your name?
Hi, Khatul.
I.
Lordship, my name is not in the list, Lordship. I
What
have
is your name?
Rahima Khatun.
Heard Miss R. Khatun, learned counsel for the applicant slash appellant. Also heard Mr.
Idai Mari, your lordship.
P. Doimari, learned counsel for the respondent.
Respondent, sole respondent.
Learned counsel for the applicant prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed. 11th of February.
Much obliged.
Ma'am, please, Your Lordship, with the consent of other side, I beg mention for the, item number 41. The engaged counsel is, having some difficulties, so may I adjourn the matter for today?
You are for?
For petitioner, Lordship.
I'm
What?
the respondent, Lordship.
What is your name?
My name is H. Das.
Heard Mr. H. You have any objection?
Lordship,
Heard Mr. H. Das, learned counsel for the
Lordship,
Appellant
engaged counsel
who-
is M. Alom.
appellant who is appearing on behalf of. Heard Mr. H. Das, appearing on behalf of Mr. M. Alam, learned counsel for the appellant who prays for an adjournment on the ground of personal difficulty of the conducting counsel. Also heard Ms. M. Nirola, learned counsel for the respondent who does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed. 17th of
February, Lordship.
February. 26th of February.
Obliged.
Please, Your Lordship. With the consent of the other side, I beg to mention item number 8, Your Lordship.
8.
8, yes. The conducting counsel, Bolkotogi is unwell today, Your Lordship. Kindly.
You have informed the other side.
Yes,
What is your name?
Rahman.
Heard Mr. M. Rahman, learned counsel for the petitioner who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. He submits that he has informed learned counsel for the respondent regarding his prayer for the adjournment, who does not have any objection to same. Hence, the prayer is allowed. Let this matter be listed. 11th of February.
May I please, Your Lordship, with the consent of the other side, I beg to mention item number 9, Lordship. Here, in this matter, Mr. N. Alam is appearing and he is out of station due to having to perform, in order to perform the annual death ritual of his grandmother, Lordship. So we have taken the consent from the other side and we have already
You are
informed.
for petitioner.
I'm for the petitioner.
Heard Mr. H. Bhakhtiar,
Yes, I Bhakhtiar.
S.A. Bhakhtiar, learned counsel for the petitioner who
Excellent.
prays for an adjournment on the ground of personal difficulty of the conducting counsel for the petitioner. He submits that he has informed learned counsel for the respondents regarding his prayer for adjournment, who does not have any objection to the same. Stop. Hence, the prayer is allowed. Let this
Lordship,
matter.
11th of March. In the month of March, any date, after 7th of March. There is an interim also, Lordship, can you may continue?
11th of March.
Interim order shall continue.
The interim order shall continue.
Much obliged.
Lordship, I beg to mention item number 17. Kindly the matter may be adjourned for today.
What is your name?
Yes, Alom.
Heard Mr. S. Alam, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty of the conducting counsel. The prayer is allowed. Let this matter be listed. 11th of February.
Please.
Motion, item number 1.
May it please, Your Lordship. Lordship, this is a civil revision petition. Lordship, the petitioner before your Lordship is the my lord plaintiff of the suit. And the impugn order is relating to my lord vacating the ex parte judgment and decree, my lord, that is passed under Order 9, Rule 13 of the CPC, my lord. Here, what had happened, my lord? The plaintiff, my lord, he instituted a suit before the Munsif Court, Golaghat.
Where is the impugn order?
Impugn order at page starts from, my lord, 84, my lord. And the operative portion is of 86. May I read, Lordship? Petition number so and so dated 15/12/2023 had been filed by the learned counsel for the petitioner defendant under Order 9 Rule 13 read with Section 151 of the CPC for setting aside the expert.
What is the wrong in the impugned order?
Yes. My lord, may kindly see the operative part, my lord, at page 86, my lord.
Yes.
Last paragraph, my lord. On such hearing of the hearing and perusal of the case record, it has been seen that summon was duly served upon the defendant on 27/10/2021, which is an admitted fact by the petitioner defendant. But no wakalatnama was filed on behalf of the petitioner defendant, from which it is clear that the defendant, petitioner defendant was under impression that he was being represented by advocate. The act of non-filing of wakalatnama is a ministerial act for which no prejudice to be caused to a litigant. Thus, the cause shown by the defendant petitioner for his non-appearance before the court on the date fixed by the court can be said to be a sufficient cause, and as such order it is so-and-so and ex parte decree it is so-and-so passed by this court is vacated. Case shall revert back to the stage of written statement.
What ground was shown by the defendant?
Yes,
What was the ground?
that your lordship will find at page number.
Where is the error?
My lord, error is that, my lord, here, my lord, what had happened while deciding an application under Order 9 Rule 13. My lord, there are two conditions, my lord. First one is that, my lord, there was no proper service of summon, my lord. That is one. And another was, my lord, if the defendant was prevented from some sufficient cause, then, my lord, court can allow the petition by whatever reason he has assigned.
Okay.
That has been as a.
At what stage the suit is pending?
My lord, it's WS has been filed, my lord, immediately after WS was filed, and now the suit is for ADR, my lord. So, my lord, let notice may go, my lord.
Okay. Heard Mr. M. Datta, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner impugning the order dated 10/11/2025 passed in Ms. J case number 133/2023 in connection with money suit number 23/2021 by the Court of Learned Civil Judge Junior Division number 1 Golaghat, whereby the ex parte judgment and order dated 1/8/2022 passed by the trial court was set aside and the suit was restored at the stage of filing of written statement. Issue notice to the respondent and call for the scanned copy of the records of Ms. J case number 133/2023 as well as money suit number 23/2021 from the Court of Learned Civil Judge Junior Division number 1 Golaghat. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th of February. List according.
Then, my lord, further proceedings.
No,
My lord, otherwise, my lord, it will be infructuous, my lord.
let it become infructuous. If not issuing notice will make your suit infructuous, if you are making such a submission, how it will become infructuous?
No, my lord, if this suit proceeds, my lord, and subsequently.
You just said that suit is in the consulate.
No, my lord, what had happened, my lord? Suit was restored, but my lord.
But
prior to this, I have
suit,
filed one
after
execution
filing of
proceeding.
WS, it is at the stage of alternative ADR process is only going on.
ADR process
That is your submission.
ADR process is going on, but subsequently, my lord, there is no scope of settlement, my lord. So therefore, my-
How we can say now?
So my lord, please.
Let the notice be
It's
served.
my-
Let the notice be served.
Then my lord may
This-
kindly observe my lord the order regarding stay my lord on next day on his appearance.
No. Let the notice be served.
My lord may observe it, my lord.
No. You cannot compel the court what to observe what. You,
Because my lord, here what had happens.
let the notice be served.
Item two,
Right, please. We have filed this civil revision petition, lordship, challenging an order for refusal as to allow additional evidence, lordship. Before going to the impugned order, lordship, I would like to draw kind attention of the honorable court, lordship, at page 15,
Page
15, a medical certificate, lordship. Annexure B. Here this certificate, lordship, one Abdul Hussain was admitted at Midland Hospital on 21/11/2025. He was discharged on 25/11/2025 with the diagnosis, lordship, infected in the right tibia, presently with unhealthy ulcer and chronic. Then clinical history, infected in the right tibia, presently with unhealthy ulcer and chronic, implant removed on 11/11, that date is important, lordship, 11/11/2025 at FAAMCH, presented with complaint of non-healing ulcer over the right leg operated area. And then finally, lordship, treatment was given above knee amputation of right lower limb with tendon injury.
Okay.
Now, lordship, the gist of the case we have.
Who is Abdul Hussain?
He is a claimant, lordship. He is a claimant, filed a MICT case in the year 2022, lordship. In the year 2025, he has adduced evidence. And that part comes, lordship, here. In the operating part at page 19 and page 20, lordship. May I read the last para of
Where is the impugned order?
page 19, lordship, last two pages. Our prayer was for allowing us to introduce the subsequent developments by way of additional evidence with this latest development amputation. Lordship, may I read the page 20,
Yes.
rather page 19 from last paragraph. A bare perusal, the case record reveals that in the case has been filed on 9/11/2022 in respect of accident dated 1/5/2022 and evidence of the claimant has been commenced 26/5/2025. However, examination in chief of the affidavit of the claimant has been submitted on 18th July 2025 and the case has been fixed for cross-examination of the plaintiff. But once again, the claimant on 13/8/25 by filing an application under Order 18 Rule 4 151 CPC has prayed for allowing the claimant to submit additional examination in chief on affidavit on the ground that at the time of filing of his examination in chief on affidavit, the certified copies of FIR, Ejahar, charge sheet, medical reports, etc. could not be submitted. After hearing both the sides, the prayer of claimant has been allowed and as such claimant submitted additional examination in chief on affidavit on 13th of August 2025. And thereafter his cross-examination was completed on 26/8/2025. Thereafter on 11/11/25 on a submission of the learned counsel of the claimant, evidence of the claimant side was closed and case has been fixed for DW. Thereafter on 11/12/25, claimant filed the instant petition again for tendering some medical bills and vouchers for his further treatment. But the evidence on record submitted in 2 installments do not reveal that he was anywhere further treated or there is any infection in the injured part. Rather, he has clarified that during cross-examination that he has not submitted any prescription regarding his present treatment. Under the above facts and circumstances, this tribunal.
When your imputation was done?
That is on 21/11, lordship. On 11/11, suddenly some infection, we have admitted in medical college, Barpeta. Implants were removed. That was not healed. Then we came to Midland Hospital. And
that fact was not made known to the tribunal.
that we had, on this 11/12, we have filed the additional petition that we may be allowed to adduce additional evidence. So far the amputation is concerned, lordship. I have annexed the petition, Lordship, at page 17. By mentioning everything, Lordship, my petition is at page 17. I have mentioned on 11/11, it was closed. On 21/1, attending doctors of Midland Hospital was compelled to ampute the right leg. And we have gone for a limited prayer, simply to introduce this latest developments.
Your prayer was objected to by the insurance company.
Yes, Lord.
On what ground? Then notice has to go.
Made by the claimant highlighting the cross-examination part of the claimants. Lordship, that was also not correct. We have given evidence having vouchers of 2022 and 2024, Lordship. And suddenly our evidence was closed in August 2025. Our implants were removed on 11/11/2025. And then imputation was on 21/11/2025.
Okay, we are issuing notice.
Case is fixed for argument. Yesterday case was fixed, but not yet uploaded.
We'll
Lordship.
put it at halt.
Lordship.
Heard Mr. S.K. Poddar, learned counsel for the petitioner. This application under Article 227 of the Constitution of India has been filed by the petitioner Abdul Hussain, impugning the order dated 17/12/2025 passed by the Motor Accident Claims Tribunal, Barpeta, in MAC case number 438/2022, whereby the prayer of the petitioner to adduce additional evidence in MAC case number 438/2022 was rejected by the tribunal. Learned counsel for the petitioner has submitted that after adducing of the evidence by the present petitioner as claimant before the Motor Accident Claims Tribunal, certain developments occurred. He had to be admitted in hospital due to infection of his injuries which he sustained in the motor accident. He was admitted to hospital on 25/11/2025 and implant on his infected tibia was removed on 11/11/2025. When it was amputated,
21, Lordship.
and later on his leg had to be amputated. His right lower limb had to be amputated on 21/11/2025. He submits that these developments were sought to be brought on record by the petitioner. However, by the impugn order, the prayer of the petitioner was rejected. His learned counsel for the petitioner submits that the aforesaid MSc case is fixed for argument before the MSc tribunal on.
It was yesterday fixed, Lordship. As per the
Tribunal.
PIS, it was not uploaded.
Oh.
Next date, Lordship.
Issue notice to the respondents. The petitioner shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of March 2026. In the meanwhile, considering the submissions made by learned counsel for the petitioner as discussed in the foregoing paragraphs, further proceeding of MSc case number 438/2022 shall remain stayed till next returnable date.
For referral to the special mediation tribe, item 3,
Oh, prohibited.
It can be referred.
No, Lordship. 3 and 4, both, Lordship, are analogous case actually. It cannot be referred to because it is not a fit case, Lordship. What we are challenging is that the liability ought to have been on both the vehicles, and the other vehicle doesn't have any insurance company, though they made Oriental Insurance a party. They do not have driver and owner are. So I think the full hearing will be needed in this case. And Mr. Mannan, Kumar Senior.
For the respondent
In
one
fact,
on
he-
behalf
What is your submission?
we have no any objection.
In referring,
He,
Yeah.
Mr. Mannan informed me that this is not a fit case, we will go for hearing that.
any objection to what? To her submission or to referring?
No, Lordship, my senior is instructed that ma'am will fix hearing.
To her submission, whatever she submits, you don't have any objection.
Maybe case will fix for hearing, Lordship.
Okay, okay.
And
And
CR
item number 4, item number 3,
number
item number 3 लिखिबो. Heard Miss R.D. Mujumdar, learned counsel for the appellant. Also heard Miss
R Begum.
R. Begum, learned counsel for respondent number 1, as well as Mr. R. Sharma, appearing for respondent number 4. Though this matter was listed today under the special mediation drive for nation to consider whether this appeal may be referred to mediation or not. However, learned counsel for the appellant has submitted that considering the issue involved in this case, a full hearing would be required in this appeal, and this is not a fit case for mediation. Learned counsel for respondent also agrees to the submissions made by learned counsel for the appellant. Hence, this matter cannot be referred to mediation at this stage. Let it be listed for hearing after 4 weeks on a date to be fixed by registry. Number 4,
same, analogous case.
parties say, okay, okay, same order.
Highly obliged.
Item 5.
May please be, Lord, as per office note dated 28.
Can it be referred to mediation?
No, Lordship, LCR has not come and 28/10/2025 service is complete, Lordship. LCR has to be summoned. Requisition LCR. Office note dated 28/10/25.
Heard Mr. A.R. Agarwal, learned counsel for the appellant.
LCR to be requisitioned.
The notice,
Notice served, Lordship. 28/10/2022, office note. Respondent number 3 issued
on
by the.
perusal of office note dated 28/10/2025. It appears that the notice issued to respondent number 1, 2, and 3 are duly served. However, the records of the MAC case number 1382/2019 has not yet been received from the concerned tribunal. Issue reminder for the same. List it after receipt of the records in hearing column.
Item 6.
Lordship can send this matter for mediation.
Mediation, okay. Heard Mr. R. Sharma, learned counsel for the appellant. Also heard Mr. A. Bhattacharya, learned counsel for respondent number 1 and 2, as well as Mr.
S. Arafat.
Mr.
S. Arafat.
S. Arafat, learned counsel for respondent number 4. This case has been listed today before this court under special mediation drive dash mediation for the nation. Stop. Learned counsel for both sides have submitted that this is a fit case to be referred to mediation. Accordingly, let this case be referred to the mediation. The record of this case be sent to the Mediation Center, Guwahati High Court. And the parties are directed to they will issue notice.
They will.
Parties are directed to appear before the mediator to be appointed by the Mediation Center, Guwahati, on the date to be fixed by the High Court Mediation Center. Let this matter be listed again for report of the mediation on which date?
After 6 weeks or 4
March, on 17th of March.
Obliged.
Item 7.
Please, your lordship. Lordship, this may be place for mediation. We have discussed about it. But lordship, in the meantime, there is a prayer for stay. So I have no objection if 20% is released. It's a case for compassionate family pension scheme.
25% may deposit.
25%.
25%.
25%.
In the stay petition, Lordship will pass a stay order, subject to deposit of 25% of the awarded amount.
Okay.
And they may be
Heard
released in product payment.
Mr. R. Goswami, learned counsel for the. There is a separate IA.
IA is there. I was not disposed of, not Lordship. Originally,
Okay.
that order was passed.
In main case, first order likho. R. Goswami, learned counsel for the appellant. Also heard Mr. S. K. Goswami, learned counsel for respondent number 1. Same team. Learned counsel for both the sides have submitted that this is a fit case to be referred to the mediation. Stop. Accordingly, let this case be sent to Guwahati High Court Mediation Center for mediation. The parties are directed to appear before the mediator to be appointed by Guwahati High Court Mediation Center on a date to be fixed by it. Let this case be listed again on 18th of March for report of the mediator. Interlocutory application. Heard both sides. This interlocutory application has been filed by the applicant insurance company under Order 41 Rule 5 of the Code of Civil Procedure, praying for, in connection with MAC Appeal number 606/2024, praying for stay of the execution of the impugned judgment and award dated 22/8/2024, passed by the Motor Accident Claims Tribunal, Hojai, in MAC case number 284/2019. Learned counsel for the claimant respondent, your claimant, does not oppose the prayer, subject to the condition of depositing 25% of the awarded amount before the registry of this court. Stop. Accordingly, the prayer is allowed.
On such deposit, that may be allowed to withdraw directly.
The execution of the impugned judgment and award dated 22/8/2024, passed by the Motor Accident Claims Tribunal, Hojai, in MAC case number 284/2019 is stayed during the pendency of the MAC Appeal number 606/2024, subject to condition that the applicant insurance company shall deposit 25% of the awarded amount before the registry of this court within 6 weeks of the date of this order. Stop. In the event of such a deposit, the registry shall disburse the same to the claimant, respondent number 1. Respondent number 1?
1.
Respondent number 1, after proper verification. This interlocutory application is accordingly disposed of.
Obliged.
Not, a date may be given for appearance before the mediation
Mediator.
center. Otherwise, what happens sometimes in the morning, someone calls up, then I cannot contact the client.
No date, they will,
Notice
because
no.
a drive is going on. We
Notice-
don't know
notice
how.
issued by the mediator.
Mediator will be issuing.
That-
There are many cases now referred to mediation center.
As per Supreme Court judgment.
Yes, so they will give date.
Notes. Obliged.
Till 10. Item number 10.
Where is the,
I have seen, my lord, my petitioner side is there, my lord.
we will wait for some time.
My,
We'll take it up after some time.
my,
Item 11.
My lords will pass over the matter for the time being. And senior is on the way.
Why?
He's on the way, my lords. He's
Okay.
pass over for the time being. Much obliged, my lord.
10 month.
Lordship, in item number 10, Lordship, I have instruction not to press the matter, Lordship.
Withdrawing.
Yes, Lordship.
Okay.
With the liberty to file appropriate application if required, Lordship.
No, why liberty again?
liberty is not at all required, my lord. Because the,
Because you are impugning a specific order.
yes, lordship, as well as, my lord, if your lordship goes to the very petition that has been filed by the petitioners in the trial court. Itself clears, my lord, all the things. Page, my lord, 31, 32, and impugn order, my lord, the lordship. will-
Heard Miss F. Ahmed, learned counsel for the petitioner. Also heard Mr. T.U. Loskar, learned counsel for the respondents. Learned counsel for the petitioner submits that the petitioner does not intend to pursue this matter and he may be allowed to withdraw this CRPIO. The prayer is allowed. This application CRPIO is dismissed on withdrawal.
Obliged.
Obliged.
Item 12.
Who is for the respondent?
My lord, Rossmann, my lord, you have taken tapes twice. Lordship may kindly look into the, my lord, last order passed by this honorable court on 5/12.
Who is the lawyer? Whether notice has been served or not.
Notice has been served, my lord, it is served, report is also there. I don't know whether trial could, my lord, the record has come.
We'll fix a short date by observing that the CRPIO shall proceed ex parte.
Losh. My lord,
Heard
maybe-
Mr. B. J. Ghosh, learned counsel for the petitioner. None has appeared for respondent side. It appears that on last occasion also, nobody appeared on for respondents in spite of due service of notice on them. This court therefore directs this CRP, the civil division petition, to proceed ex parte against respondent. How many against the respondents?
Against,
Let this matter be listed at Ashwin. 9th of February for
Right.
ex,
And that
Why?
can be disposed of, my lord.
for ex parte
Yes,
hearing.
yes. Obliged.
Item 16.
Definitely, Lordship. This is an appeal on quantum, Lordship. It's an injury case.
Heard Mr. R. Goswami, learned counsel for the appellant insurance company. This appeal under section 173 of the MV Act, 1988 has been filed by the New India Assurance Company Limited, impugning the judgment and award dated 19/2/2025 passed by the Motor Accident Claims Tribunal Nalbari in MSC case number 24/2021. Stop. The appellant is aggrieved mainly with the quantum of the compensation awarded to the claimant. Stop. Issue notice to the respondent. The appellant shall take steps for issuance of notice upon the
Lordship,
respondents.
In this case, the respondent had appeared also. Delay
Where?
has been condoned, copy has been started.
No, that is in the delay condonation. In the main case, you have to again take steps. By speed post as well as by usual mode within 7 days from the date of this order, returnable on 27th February.
Subject to deposit of stay
No, stay. Stay is required.
is required.
Then deposit 50%.
Yes, Lordship.
Heard Mr. R. Goswami. This interlocutory application has been filed. Agot, order of this appeal is admitted. This appeal is admitted. This application under Order 41 Rule 5 of the Code of Civil Procedure has been filed by the applicant/appellant in connection with MSC case number 570/2025, praying for stay of the execution of judgment and award dated 19/2/2025 passed by the Motor Accident Claims Tribunal Nalbari in MSC case number 24/2021 within bracket injury. Stop. The aforesaid judgment and award has been impugned by the insurance company applicant in the connected MSC appeal. Since the applicant is ready to abide by any condition which may be imposed in the condition of grant of stay as prayed for him, as prayed for by it, this court is disposing of this interlocutory application without issuing notice to the respondent. Stop. The impugned judgment and the execution of impugned judgment and award dated 19/2/2025 passed by the MAC Motor Accident Claims Tribunal Nalbari in MSC case number 25/21 within bracket injury is hereby stayed subject to payment of 50% of the awarded amount subject to deposit of 50% of the awarded amount by the applicant before the registry of this court within 6 weeks of the date of this order. This interlocutory application is accordingly disposed of.
Orders, item 18.
Lord, this matter has been remanded back from Supreme Court. Let it come for hearing.
It is ready for hearing.
It was already heard and decided, and the respondent side went to Supreme Court, and Supreme Court has remanded it back.
Heard Mr. A. Dhar, learned counsel for the appellant. Also heard Miss
B Hajarika.
B. Hajorika, appearing for the respondents. Let this matter be listed for hearing on
In the month of March.
19th of March.
Your Lordship, can it be before 19th?
Before 12th of March.
Oh, nice.
Item 19.
My Lordship, as per Office Note 51/2026, the service upon respondent is still awaited.
Who has not appeared? Which respondent?
He's a driver, Lord.
The owner.
Owner, Lord.
Respondent number 2.
Yes, Lord.
When have you taken steps?
As per last order dated 5/12, Lordship, they have not taken step very long period, and here is stay has been granted without any deposit, Lordship.
Respondent number 2.
Yes.
We will wait for a few days and ask the registry to place the track consignment. Heard Miss, what is your name?
M Chetia.
M. Setia, learned counsel for the appellant. Also heard Mr. S. Deka, learned counsel for respondent number 1, as well as Miss. What is your name? What is your name? P. Goswami, appearing for respondent number 3. On perusal of the office note dated 5/1/2026, it appears that the notice issued to respondent number 2 has not yet returned. Stop. The registry is directed to place the postal track consignment report of the notice issued to respondent number 2 by speed post on the next date fixed. Let this matter be listed. 13th February.
On that day, I will be disposed.
Let us see.
Item 20.
They have any objection regarding IA?
Yes, Lordship, without depositing, because basically they have filed
They
a
have, matter has already been stayed.
state without any deposit, Lordship.
Okay.
I am for the claim.
And the IA is disposed of or it is still
Life,
pending?
still life.
You have any objection in paying 50%?
No, my Lordship.
No objection.
50% may be deposited, Lordship.
Then we will dispose it of today.
My Lordship,
Or you don't have any instructions?
I'll have to ask my senior counsel.
Okay, let them take instruction. On the next date, we will decide.
20.
May it please your Lordship.
Yes.
Lordship, as per office note dated 22/1/2026, Lordship, AD card has not been received regarding service of notice upon respondent number 3, Lordship. On the last occasion,
When have you taken steps?
we have taken steps on 28/10/2025, Lordship.
Okay, then we'll direct the registry to place track consignment.
Lordship.
Heard Mr. P. Bordole, learned counsel for the appellant. Also heard Ms. K. Sharma, learned counsel for respondent number 1 and 2. It appears from the office note dated 22/1/2026 that the notice issued to respondent number 3 has not yet returned. Stop. The registry is directed to place the postal track consignment report of notice issued to respondent number 3 by speed post before this court on the next date fixed. List this matter on 13th of February.
Lordship. Oblige, your Lordship.
Item 21.
Well, I'm the respondent here, Miller. What happened on the last occasion, the petitioners were asked to take steps on the respondents, Miller, by Dusty Service 4 to 7, apart from other Miller usual courses. Miller, this is a collusive petition, Miller. In fact, the petitioners, Miller, respondents who are not served, Miller, they were actually the title decree holder. They could not execute the decree, could not stall the execution of the decree. Then they've projected this person as a caretaker. She was supposed to be the earlier caretaker. This person has filed this application, objecting to the execution proceedings. Now, the steps were not taken. The service is not completed. Respondent 4 to 7, and there's a direction to take the service on the respondent.
You have taken steps.
Lordship, my senior counsel is in another court. Kindly possible for timing.
No.
To my
Have
knowledge,
have you taken steps or not?
to my knowledge, well, it's not been taken.
I'm not aware with the fact.
Why you are not aware?
Today morning only.
You should take instructions before. What is to be done? No fresh steps to be taken by the council.
They're enjoying.
You have not taken steps.
They're enjoying the stay, my lord, then my lord.
Okay. Then we'll take it up after some time. If you have not taken steps, then we will vacate this stay. You tell your senior. We'll take it up after some time.
22.
May I please, your lordship?
Please, your lordship, I appear on behalf of the respondent in this matter, my lords.
22.
This is
What is this?
a limitation application, your lordship, in regard to a section 37 application filed before this honorable court. Your lordship had heard analogous matter earlier. Analogous in the sense this case was transferred from IJOB, where there was a delay. Your lordship was pleased to on an earlier occasion condone the delay with regard to this. Now, what has happened is, your lordship, if your lordship takes up this particular IA 200.
How much delay is there?
Actually,
That the registration number was changed.
yes, yes, that was there. That was the earlier case. Now, this is the original record which was there. Now it has been renumbered as 208. Earlier it was IA 1 of 22. Now it has been renumbered at 2008 of 23. So your lordship was aware of that. Your lordship was pleased to condone the earlier delay.
Where is the earlier order? Okay, what is yours?
My contention here, your lordship, there are delay of, as per the record, it is 5 days delay.
How much?
5 days.
Only 5.
Only 5 days.
How you have explained?
Your lordship will find, though it was not drafted, your lordship will find, because I'll just place a chart I had prepared, because this was not drafted by me, just for the sake of assisting this court.
Are you opposing?
It's a short delay of 5 days. I leave it to my lord's judgment.
Okay, then
What I do.
We are you are opposing.
No, I'm saying the same side, your lordship.
Okay, then we are
Well,
condoning the
What I do want to, if my lords deem fit, I do want to get noted down is the conduct of this party, my lords. My lords,
No,
the section
today
30.
we will not go into those issues.
Of course, my lords, but
We'll-
in terms of the order, in terms of the allowing of this condonation, my lords, this award was rendered in this award was rendered in 2019. Thereafter, today in 2026 as well, my lords, there is again a condonation of delay. Thereafter, a restoration. Then after a condonation of delay of that restoration. So that conduct, my lords, is
No,
something
this
that I just want to
condonation of
point out.
delay is for what?
My lords, this condonation is for 37. This is the
37
first.
appeal.
This is the
appeal.
first condonation. Yes, my lord.
Okay. Heard. Mr. A. Bishwas, learned counsel for the applicant. Also heard Mr. What is your name?
Shashwat Chandra, my lords.
S. Chandran.
Chandra, sir.
S. Chandra, your lordship.
S. Chandra, learned counsel for respondent number.
Sole respondent.
For the sole respondent. This application under section 5 of the Limitation Act 1963 has been filed by the applicant for condoning the delay of 5 days in preferring the connected appeal, whereby the applicant has impugned the order dated 30/11/2021 passed by the learned district judge
Number 2.
number 2 Aizawl,
Additional
Judicial District Aizawl in arbitration petition.
Additional district judge.
Learned additional district judge Aizawl. Learned additional district judge number 2 Aizawl, Judicial District Aizawl in arbitration petition number 1
Of
slash
2020.
of 2020. Learned counsel for the petitioner has submitted that the petitioner has explained the reasons for approaching the court in filing the connected appeal beyond the period of limitation, beyond the prescribed period of limitation in paragraph number
It starts from para 3, Your Lordship.
3 to 6
Yes.
of the instant revision petition. He submits that considering the fact that only 5 days of delay has been caused in preferring the connected appeal, as well as considering the reasons shown by the petitioner, the delay may be condoned. Learned counsel for the respondent, on the other hand, has submitted that though considering the short period of 5 days delay, he is not opposing the prayer for condonation of delay. However, he submits that the petitioner's conduct may be noticed by this court in as much as his earlier application were also which application were delay were caused?
For this present IA, there was it was dismissed for non-prosecution. Thereafter, there was a restoration application, which was filed with the 126 days of delay, my lords.
That the delay condonation application was dismissed.
Your Lordship was pleased to allow it.
It was allowed by your lord.
It was allowed by
After
your
the
lordship.
restoration was filed, my lords. It was previously it was dismissed.
5/12 of 25.
Stop. I have considered the submissions made by learned counsel for both sides. Considering the reasons shown by the applicant in paragraph number 3 to 7 of the instant interlocutory application, as well as considering the fact that the delay is of a very short period of 5 days only, the said delay is hereby condoned and this interlocutory application is allowed. The registry is directed to, it has already been renumbered.
No, it has filing number is given, Your Lordship.
Registry is directed to register the connected arbitration appeal and list the same for admission. When?
Any date, Your Lordship.
My lords may give a specified date so that my lords we can.
Suggest.
My lords, if we also
13th of February.
Yes, Your Lordship.
List this matter on 13th of February.
Please, my lords.
Oblige, your lord.
23.
This I is disposed of.
My lords.
Oblige, your lord.
Obliged.
Obliged.
Item.
Lordship, I am appearing on request of Mr. M. Soikia, Lordship. Lordship, we want to withdraw this matter.
What is your name?
C. Kolita.
Heard Mr. C. Kolita appearing on behalf of Mr. Item number M. Soikia, learned counsel for the petitioner, who submits that yes, you have instructions. He has been instructed by the petitioner to withdraw this instant interlocutory application. This interlocutory application is, and the RSA?
Both case, Lordship.
Okay. This interlocutory application is accordingly dismissed on withdrawal. This case is for what purpose? Section 5. In view of the RSA case. Orders of. Okay, okay. Okay, in this case, sort of in view of the no, same order, praise for withdrawn. This is dismissed on withdrawal.
Much of.
Item 24.
May I please? In this case, service completed, my lord. Only the lawyer court record in the original suit. And the my lord, reminder also issued, my lord, by the registry, but has not reached to you.
Heard Mr.
Yes, please, yeah, my lord.
S. Soikia, learned counsel for the appellant. On perusal of the office note dated 28/1/2026, it appears that the records of the trial court within bracket title suit number 60/2010 has not yet been received. Stop. Issue reminder to the for the same. Registry to issue reminder. List this matter again on. No.
After reaching
2nd of March, after receipt of the trial court records.
Item 25.
May I please, Your Lordships? Office note dated 28/1/2006 reveals that the service upon respondent number 3 and 4 complete. So for respondent number 1 and 2, my lord, the address is left the district. So we could not ascertain the proper address of the respondent number 1 and 2. And so far 5, 6 and 7, well, they were the pro forma. They did not contest. So their name may be 5, 6, 7, maybe.
No, nothing, no striking out business.
That is.
We will, what will happen as regards 1 and 2?
1 and 2, my lord, the office note reflects that they left the district.
Now what is to be done?
My lord, they are the, my lord, the same respondents. So they can provide the address if.
You have the address of 1 and 2. Oh, they are appearing for respondent number 3 and 4.
3 and 4.
1 and 3 and 4.
3 and 4. What is your relation with 1 and 2? How they are related to 1 and 2?
They are the dependent number 1 and dependent number 3 and 4. They are dependent.
Now, are they related to each other?
No, they are the 1 and 2 are seller of the suit land to respondent number 3 and 4.
How they will know the address?
They may not know.
They may be in your.
That is correct.
So that's it, that too, we have to take instructions, that's it.
If they.
Let them take instructions. And you also in the meanwhile find
I will
find out. Heard Mr. N. Hawk, learned counsel for the appellants. Also heard Miss, what is your name?
Padar.
A. Tapadar, learned counsel for respondent number 3 and 4. On perusal of the office note dated 28/1/2026, it appears that the notice sent to respondent number 1 and 2 have returned with a postal endorsement within inverted comma. This person does not live at this address but lives in another district. Stop. Inverted comma. Close. Return to sender. It also appears that notices issued to respondent number 5, 6 and 7 have not yet returned. The learned counsel for the petitioner prays for learned counsel for the appellant prays for some time to find out the proper address of respondent number 1 and 2. The learned counsel for the respondent number 3 and 4 is also requested to let this court know on the next date fixed as to whether they know the proper address of the respondent number 1 and 2. The registry is also directed to place the postal track consignment report of notices issued to respondent number 5, 6 and 7 before this court on the next date fixed. let this matter be listed 11th of February.
Item 27.
Please, your lordship. In this matter, my lord, very first day the record was called for. Record is anything. My lord, in that case, notice may be issued, my lord, to other party. Notice not been issued so far.
Notice has not been issued.
So far, yes.
Heard Mr. C. Barua,
My lord,
learned counsel for the petitioner.
my lord. First order was 16/11/2024. 6/11, it is not.
It appears from record that though in this case, trial court records, scan copy of the trial court records have been called for. However, no notice has yet been issued to the respondent side. Hence, issue notice to the respondent. The petitioner shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th February, list accordingly.
My lord, may I pay for further proceeding? If this setting,
Because you have pointed out to this court regarding issuance of notice
no, that's because that is.
after so many dates.
No, that was because last order your lordship received, this record was not received. That is why.
No, but you should have pointed out to the court that notice is have not yet issued. So many dates, more than.
Maybe that's, I may be wrong.
Okay. Let the other side appear.
Obliged.
Item 28.
May I be lordship? My senior is not well, my lord, today. My lord. Maybe listed next week, my lord.
Why it is in orders column?
It's for condonation of delay petition, my lord.
Okay. Heard Mr. T. Sheikh, learned counsel for the applicant. Also heard Mr.
B.B. Kakoti.
B.B. Kakoti, learned counsel for the respondent. Learned counsel for the applicant has prayed for an adjournment on the ground that the conducting counsel for the applicant is indisposed. The learned counsel for the respondent has not opposed the prayer. Hence, the same is allowed. Let this matter be listed 4th of February.
Item 29.
Yeah, please, before lordship. In the last order by your lordship, it was directed to submit copy of the case to Standing Council of Review. They have already submitted on 20th January. Here is some urgency, my lord, to hear this case. My lord, actually, in this case, we want to withdraw some amount of awarded money, my lord, which is fixed on the bank of respondent number 2 at Port Beta on the ground of serious illness.
Who is appearing for the respondent?
We have submitted copy, my lord, already, Standing Council to you, 20th January, my lord, as per earlier order of this court.
This is item number?
Item number 20.
Standing Council Railways.
Yes.
Who is this standing council? To whom you have served the copy? Not to whom you have served the copies. You find out, we'll take it after some time. You find out if he is available or not.
Yes.
We'll take it up after some time. In the second half, we'll take it.
Item 30.
Your Lordship,
Yes.
as per office note dated 28/1/26, no service report has been received for the respondent number 1 to 4 and for former respondent number 6 to 8. The answer has been received.
Service is complete.
No, await service.
Oh. You have not taken steps by speed post. You have to take, because that was the direction. Usual mode as well as speed post also. Heard Miss, what is your name?
Borwa. You Borwa. You Borwa.
Heard Miss U. Borwa, learned counsel for the appellant. On perusal of the office note, it appears that the notices issued to respondents by usual process have not yet been received. However, it also appears that the appellant has not taken any steps for issuance of notice by way of speed post. Stop. The appellant is again directed to take fresh steps for issuance of notice by speed post within 7 days from the date of this order, returnable on 2nd of March 2026. The records of the trial court as well as first appellate court have already been received. List this matter accordingly.
Item 31.
Wait, please, Your Lordship. Lord, connected appeal is barred by time, my lord. So, my lord, the opposite party takes time for filing objection.
Who is for
I
the-
refer to order dated 17/12/2025. Other occasions also, my lord, they take time.
How much delay is there?
Delay is considerable, my lord, 707.
Okay, let them file an objection.
But the thing is this, my lord, they are not appearing even today.
Government is on the other side.
Railway, my lord.
We'll give one more chance. Heard Mr. M.H.
My lord, this may be recorded that on 17 that
Okay. Heard Mr. M.H.
they are absent.
Learned counsel for the applicant. None has appeared for the respondents. Stop. On perusal of the records, it appears that by order dated 17/12/2025, the respondent number 2 was allowed to file written objection against the prayer for condemnation of the delay filed by the present petitioner. However, no such objection has been filed. Neither any counsel is present there to represent the said respondent. Stop. However, considering the fact that 700,
7 days.
considering the fact the delay involved in this case is 707 days, one more chance is granted to the respondent to file written objection. 13th February. List this matter on 13th February.
Item 33.
I think
May I please, Your Lordship?
yes.
My lord, there is a IA, my lord.
For
IA for condonation of delay, my lord, 1101 IA limitation. In preparing, my lord, substituting the legal heirs of the respondent number, sole respondent number 1, my lord, in this matter. Aftabuddin Borbuya.
how much is the delay?
Delay, is, my lord, 533 days, my lord.
Okay, why is the
My lord, it has been explained in the application, it is at page 6, paragraph 3 and 4, my lord. More particularly, my lord, it was, my lord, earlier time, Dr. B. Ahmed, my lord, he was entrusted with the case, my lord, and after that, my lord, he fell ill and paragraph 4, my lord. May I read?
Yes, you can, yes. It is a long paragraph.
Long para, my lord. And
What is? Mr. B. Ahmed is suffering from some illness.
Yes, my lord. Till date, my lord, he is suffering.
He's not coming to courts.
My lord,
He's not coming to court.
no, my lord. It is well from.
Okay. Thereafter, what happened?
Thereafter, my lord, the file was in the, my lord, paragraph 7, my lord. Paragraph page 7, my lord, in middle part, my lord. In this process, 533 days got lapsed. However, recently the applicant received the file and engaged the present sets of advocates, and accordingly, the application for clarification of legal heirs have been prepared and is filed praying for appropriate relief. Therefore, there is no willful delay on the part of the applicant and in pursuing the matter of moving the application, praying for substitution of the legal heirs.
When you came to know about the death?
Death, my lord, he died, my lord, on 11/3/2023.
Yes. When it came to your notice?
Last paragraph 3, my lord. Accordingly, the applicant successfully gathered information regarding the legal heirs of late Aftabuddin Borbuya, sole respondent, and provided the details of the legal heirs of Aftabuddin Borbuya, respondent to their engaged counsel, B. Ahmed, in the last week of March 2023.
Okay. In the March 2023 itself, you have informed your engaged counsel. Yes, you are objecting.
Yes, my lord. So the Lordship record would reveal that, my lord, there are other counsels were there, my lord. And when this appeal was admitted, learned counsel N. Hoku appeared there in the case, my lord. Regarding that, my lord, the explanation they given in their application for condemnation delay is not sufficient, considering the fact that, my lord, all along in 1 or 2 occasions, Dr. Ahmed was there, my lord. And there are sets of lawyers there, my lord. They have, my lord, they have represented on several occasions, my lord. And my lord, in this regard, my lord, in the last week of March 2023, they have handed over the records to Dr. Ahmed. And surprisingly, the application was filed on, I have received on 17/3/25, my lord. They could have pursued with their counsel why it was filed or not filed, my lord. And my lord, regarding this, my lord, I will place before your lordship the judgment of the apex court, my lord, sufficient court, my lord, Banswaraj and another, my lord, special land acquisition case, my lord, para 15. Paragraph 15, my lord. The law on the issue can be married.
Yes.
The law on the issue can be summarized to the effect that whether a case B has been presented in the court beyond limitation, the applicant has to explain the court as to what was the sufficient cause, which means an adequate and enough reason which prevented him to approach.
You were plenty for defendant in the.
My lord, earlier occasion, my lord. Welcome, my lord.
Suit, my lord.
Whose suit was it?
Suit was filed by the
I am not, I am.
respondent,
I am suit filed by the respondent, my lord. The respondent was the plaintiff, my lord. I am the defendant.
defendant.
And suit was decreed.
Agreed,
Suit decreed, my lord.
It is a suit for
righted and interest, my lord.
and recovery of possession also.
Yes, my lord. Confirmation of possession.
Who is in possession?
At present, I am in possession.
You are in
My
possession. Okay. Okay. Then what is it? Please read
My
15.
lord, a sufficient cause, which means an adequate and enough reason which prevented him to approach the court within limitation. In a case, in case a party is found to be negligent or for want of bona fide on his part in the facts and circumstances of the case, or found to have not acted diligently or remained inactive, there cannot be a justified ground to condone the delay. No court would be justified in condoning such an inordinate delay by imposing any condition whatsoever. The application is to be decided only within parameters laid down by this court in regard to condonation of delay. In case there was no sufficient cause to prevent a litigant to approach the court on the time condoning the delay without any justification, putting any condition whatsoever amounts in passing in an order violation of the statutory provision and is tantamount of showing utter disregard to the legislature. Now, my lord, the
Yes.
in the instant case, my lord, only showing that they have approached Dr. Ahmed in the last week of March 2023, my lord. And they have handed over all sorts of documents to him to file an application, my lord. That case, there are other counsel, my lord. Wakalatnama has been filed in this court, my lord. Other sets of lawyers are there, my lord. And on that cannot be a ground, sufficient ground. In this line, similar judgment has been, my lord, referred in other judgments also, my lord, in 2029 also, my lord, and 21 also, my lord.
Heard, Mr.
My lord.
Yes.
Applicant before your lordship, my lord, with a, my lord, inhabitant of Hailakandi is in remote corner of the village, my lord. And he not negligent, my lord. The file was with the custody of Mr. B. Ahmed, my lord. Several times he approached, my lord.
Okay, heard, Mr.
My lord.
PU.
My lord, regarding a remote area, my lord, he hails from Walipar, my lord. This is not a remote area, my lord.
Walipar is a part,
not remote area.
PU Laskar, learned counsel for the applicant. Also heard Mr. J. Laskar, learned counsel for respondents. This application under Section 5 of the Limitation Act has been preferred by the applicants, praying for condonation of delay of 533 days in filing the application for setting aside abatement of the connected regular second appeal number 73/2016 due to death of the respondent number 1, late Aftabuddin Borbhuya, on 11th February 2023.
March, my lord.
11th March.
March.
Or you have mentioned here in 11th February in page number 3. Which date is correct? Page number 13. Where have you mentioned it?
My lord, paragraph 2 at page 6, ma'am, of the application.
11th March
March.
2013, during pendency of the appeal. How many applications have you filed?
Three,
Ah, Separate. This one is for condonation of delay.
condonation of delay.
Okay. Learned counsel for the petitioner has submitted that after death of the respondent number 1 on 11/3/2025, the appellants came to know about the same in the last week of March, and accordingly they collected the details of about the legal heirs of deceased respondent number 1 and provided this said detail to their engaged counsel, Dr. Burhanuddin Ahmed. Stop. It is submitted by learned counsel for the applicants that the engaged counsel for the applicants, Mr. B. Ahmed, was suffering from ailments for which he had to be admitted in a hospital in Bangalore. And due to his prolonged illness, he could not take steps for filing of the filing of the application for setting aside abatement and other connected applications. He submits that the petitioner is the resident in a remote village in the district of Hailakandi, and therefore it was difficult on his part to keep constant touch with his engaged counsel, and as a result of which a delay of 533 days has occurred in filing the application for setting aside abatement and substitution petitions. Learned counsel for the applicant submits that how many appellants are there? Many appellants. The applicants were prevented from approaching this court in filing the connected interlocutory application within prescribed period of time, as same were beyond his control, and there was no willful negligence on his part. Hence, he has prayed for condoning the delay of 533 days. On the other hand, Mr. J. Ahmed, learned counsel for the respondents, has submitted that the applicants were negligent in pursuing their cause, as they have failed, as it appears from their petition itself that they came to know about death of the respondent number 1 in the month of March 2023 itself. However, the applications for substituting the legal heirs as well as for setting aside the abatement were filed in the year were filed on 22/11/2025 after a huge delay of 533 days. He submits that the reasons shown by the applicant in their application may not be regarded as sufficient cause which prevented them from approaching the court within the prescribed period of limitation, inasmuch as, apart from Mr. B. Ahmed, there were other lawyers who were engaged by the appellant in the connected appeal. He submits that the applicant were negligent in not approaching the other lawyers. He further submits that the applicants are therefore negligent and have not acted diligently and remain inactive for a long period of 522 days. And therefore the delay should not be condoned. In support of his submission, he has cited a ruling of the Apex Court in the case of Basavaraj and another versus the Special Land Acquisition Officer within bracket Civil Appeal number 6974/2013. I have considered the submissions made by learned counsel for both sides and has also gone through the materials available on record. Though while dealing with an application under Section 5 of the Limitation Act, the court has to take a justice-oriented approach and have to be liberal in those cases where the applicant is able to show sufficient cause which prevented him or / them from approaching the court within the prescribed period of limitation. However, in a case where it is apparent that the applicant is negligent or there is a want of bona fide on his part, the delay may not be condoned. In the instant case, the applicants are resident of Hailakandi, and it appears from their application, which is supported by affidavit, that they have given the details of the legal heirs of the deceased respondent number 1 to their engaged counsel in the month of March 2023 itself, that is within the prescribed period of limitation for however, the cause shown by them, that is their engaged counsel was suffering from various ailments, is beyond their control. In the instant case, the first appeal, what was the decision of the first appellate court?
But, first appeal, my lord,
Who was the plaintiff?
Plaintiff, the present respondent is the,
You are the plaintiff. Your suit was decreed.
suit was
Suit was dismissed.
then I went to appeal my, appeal was decreed.
Your possession was confirmed.
My lord.
Stop. It
Your
also,
possession
it also appears that the suit land is presently in possession of the respondent, as the first appellate court has confirmed his possession, and therefore there may not be any cause. Therefore, the appellant could not have benefited by protracting the litigation, and therefore no malafide can be attributed to them. Stop. After considering the reasons shown in paragraph number 3 and 4 of the application for condonation of delay to be sufficient reasons which prevented the present applicants in approaching this court within the prescribed period of limitation for filing the application for setting aside abatement and other connected and application for substitution of the legal heirs. This court hereby condones the delay of 533 days in filing the connected interlocutory applications. This interlocutory application is accordingly allowed, and the delay of 533 days is hereby condoned. Other two applications?
For setting aside abatement, my lord, and the substitution of legal heirs of the respondent. 1103, my lord, is for substitution. And 1105 is for setting aside abatement.
Any submission?
My lord, there's delay has condoned, my lord.
Okay. Heard Mr. T. Uloscar, learned counsel for the applicant. Also heard Mr. J. Uloscar, learned counsel for the respondents. This application under Order 22, Rule 4 of the Code of Civil Procedure has been filed by the applicants for setting aside abatement of RSA number 73/2016 due to the death of respondent number 1, namely Aftab Uddin Bordhuya, on on 11/3/2023. Stop. There was a delay in preferring the instant interlocutory application, which has already been which has already been condoned in interlocutory application number 1101/2025. Stop. After considering the grounds stated in paragraph number 3 and 4 of the instant application, the abatement of connected regular second appeal on death of the respondent number 1 is hereby set aside, and this interlocutory application is allowed. 1105 next. This interlocutory application has been filed by the applicants under Order 22, Rule 3 of the Code of Civil Procedure for substituting the legal heirs of the sole respondent in RSA number 73/2016. the sole respondent expired on 11/3/2023. And the delay in preferring the instant application has already been condoned by this court in interlocutory application number 1101/2025. For reasons, for the grounds stated in the, who are the legal heirs?
Wife and son and daughter. Paragraph full paper, full paper.
How many?
Paragraph, my lord, your lordship will find paragraph 2, my lord. Paragraph 2 at page 6.
Who are the, what are names?
Noor Khatun Chaudhary, wife.
On, for reasons shown in the, for considering the grounds stated in the instant application, the legal heirs of late Aftabuddin are allowed to be substituted in his place as the substituted respondents. Stop. Accordingly, Srimati Noor Khatun Chaudhary, Saleh Ahmed Borbhuya, Hussein Ahmed Borbhuya, and Husna Begum Borbhuya are substituted as respondent number 1A, 1B, 1C, and 1D in the connected regular second appeal in place of the deceased respondent Aftabuddin Borbhuya. The appellant is directed to submit the corrected cause title in the cause title of the memo of appeal, showing the names of the substituted respondents therein within a week from the date of this order. Let this matter be listed. Again, let the connected regular second appeal be listed. At what stage it was pending?
My lord, already LCR has received, my lord, for hearing.
For hearing.
In orders column, we will fix. In orders column, in the second week of February.
Right. High level.
Item 44.
May it lordship में पहले last order ये lordship. Asked in IA civil number 3244/2025.
My lord, respondent number 1 expired and the legal heir of has been substituted.
They were supposed to provide the names of the legal heirs.
Today I am doing.
You have provided,
Just now, your lord, they provided.
so you will take steps.
Yes, your lord.
Heard Mr. S.
A Das, your lord.
A. Das,
On behalf of Mr. S. Bharal, your lord.
appearing on behalf of Mr. S. Bharali, learned counsel for the applicant. Also heard Mr.
L. Deka.
L. Deka,
On behalf of M. Datta.
appearing for respondent number 1 and 2. Who expired?
Respondent number 1, my lord.
Learned counsel for the applicant has submitted that the learned counsel for respondents
Opposite party number 1, your lord. Yes.
has furnished the list of legal heirs of deceased opposite party number 1, late Jatindra Kumar Roy, today only, and therefore he prays for some time to take appropriate steps for filing substitution petition,
Yes, your lord.
filing appropriate petition in that regard. The prayer is allowed. Let this matter be listed after
Filing of the IA for substitution of the legal heirs, your lord.
okay, after 4 weeks.
Yes.
After 4 weeks.
Much obliged, your lord.
Item 35.
May it please your lordship. Kindly see order dated 5/12/2025 already appeal has been admitted, lower court records has been called for, my lord, delay has been condoned. Today's is for stay of the, my lord, order, that impugn order, as because execution case is going on there, my lord, trial court. So, my lord. Already, my lord, I have produced.
This I is for what?
My lord, stay of the
Yeah, my lord.
impugned order, my.
Yes, my lord. Main, my lord.
Execution case has been,
Yes, my lord, I have
Yes.
you have
submitted.
any objection?
No, my lord.
Heard Miss S. Bora, learned counsel for the applicant. Also heard Mr. G. Imtiaz,
Yes.
learned counsel for
The respondent number one, my lord.
respondent number 1. This application under Order 41, Rule 5, read with Section 151 of the Code of Civil Procedure, has been filed by the applicant / appellant, praying for stay of execution of the impugned judgment and decree passed by the
Is for, my lord.
trial court in
Title suit number.
title suit number 272/2010 on 24/10/2024. Stop. Learned counsel for the petitioner has submitted that the connected regular first appeal, wherein the present applicant has impugned the judgment and decree of the trial court, has already been admitted for hearing, and the opposite parties and the respondents have also appeared.
Yes.
She therefore, she also submits that in the meanwhile, an execution case bearing number, what is the number?
38 of 2024.
Execution case number 48/2024 has already been registered before the executing court, and same is required to be stayed during the pendency of the connected appeal.
69 of.
Stop. The learned counsel for respondent has not opposed the prayer of the petition applicant. Stop. Considering the submissions made by learned counsel for the petitioner, the prayer is allowed. During the pendency of the connected regular first appeal number 69/2025, the execution of the impugned judgment and decree in the execution case number 48/2024 shall remain stayed. This interlocutory application is accordingly disposed of.
My lord, a date may be fixed, my lord, wherein this.
For appeal.
Yes, my. My lord, in the first week of April, my lord.
April.
Yes.
Records have come? No, records have to come first. Heard both parties, same parties. On perusal of the office note dated 19/1/2026, it appears that the records of the trial court have not yet been received. Stop. Issue reminder to the issue reminder for the same. Registry to take steps for issuance of reminder. Let this case be listed again in the month of April after receipt of
Yes. My lord,
trial
a
court
date may be
records.
fixed, my lord.
In the first week of April after receipt of trial court records.
Deeply obliged.
Item 36.
May I please, your lordship? When this case, the instant application has been filed for correction of some typographical mistake in the names of the legal heir, lordship. What has happened, lordship, while filing the application for substitution, the name of the deceased, respondent number 7, in there has been mentioned. And while mentioning the name of the deceased respondent number 7, the legal heirs, the respondent number 7.2 has been wrongly mentioned as Jivan Chandra Rajbangshi instead of Jimbu Rajbangshi. So this is the basic, your lordship, for allowing the appellant to make necessary correction in the name of the legal of the respondent number, sir. This is
In
respondent.
the substitution application.
Exactly, Lordship. IS civil number 3426 of 25, Lordship.
You have no objection.
I have no. I have responded now 226, my lord.
You also don't have any objection. Heard Mr. S.P. Chaudhary, learned counsel for the applicant. Also heard Mr. What is your name?
M. Pandit,
M. Pandit, learned counsel for
respondent number 226.
respondent number 226, as well as Miss B. Hajorika appearing for respondent number 1. This interlocutory application has been filed by the applicants under section 151 of the Code of Civil Procedure. Where is the order?
Lordship, order is at annexure 1, Lordship. The page number 16.
Praying for correction of a typographical mistake which has crept in the order dated
2111. Page number 18, Lordship.
order dated 21/11/2025, passed by this court in IA civil number 3426/2024. Learned counsel for the petitioner has submitted that in which paragraph?
Lordship, it is there in paragraph number 4.
No, in the order.
Oh, order, Lordship, page number 19.
Which para?
Page number 19, the third paragraph. He submits that the legal heirs of deceased respondent, namely Sri Satyajit Rajvanshi and Sri Jiban Chandra Rajvanshi, may accordingly be substituted.
What should be the correct spelling?
Jimbu Rajvanshi, Lordship. The second one, the Jiban Chandra Rajvanshi. In paragraph 4, page number 10, I made it.
ZIMBU.
Yes, Lordship. JIMBU. It is there in page number 10, Lordship, paragraph 4.
Kile, last line. Shamina. Submitted that in this aforesaid order dated 21/11/2025, the name of legal heir of respondent number 7 has been shown in paragraph number 3 as well as paragraph number 7 of the said of order as Shri Jiban Chandra Rajvanshi instead of Shri Jimbu
It is
Rajvanshi.
there at page number 21, Lordship. Aadhaar card I have annexed, Lordship.
JIMBU.
Page number 21.
He submits that same is required to be corrected. Learned counsel for the respondent side does not oppose the prayer. Stop. On perusal of the aforesaid order, it appears that the mistake in the name of respondent number 7
7.2, Lordship.
7.1 7 or 7.
7.2, Lordship. 7.2. That means 7.1 is the first son, and the 7.2 is the second son.
7.2 has been crept in due to typographical mistake, and same is required to be corrected. Accordingly, the name Jiban Chandra Rajvanshi shown in paragraph number 3 and 6 of order dated 21/11/2025, passed in IA civil number 3426/2025, shall be read as Shri Jimbu Rajbanshi in place of Shri Jiban Chandra Rajbanshi. This interlocutory application is accordingly allowed and disposed of.
Lordship, whether I'll file an, this amended cross title.
That direction is already there.
No, with regard to the Jimbu Rajbanshi, sir, whether I'll file an additional, this one.
Yes.
By incorporating.
The appellant is directed to file an amended cause title showing the correct name, that is Jimbu Rajbanshi, therein. Let this matter be listed in the second week of February on a date to be fixed by registry. B. Hajurika for respondent number 8. Agud.
Item 47.
May it please your lordship. Lordship, this I is for condoning the delay of 58 days in filing this appeal, lordship.
8. Heard Miss M. Soikia, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been filed by the applicant / appellant insurance company for condoning the delay of 58 days in filing the connected miscellaneous first appeal. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th February.
Please, lordship.
Item 38.
Heard Mr. M. M. Zaman, learned counsel for the applicant. This application has been filed under proviso to Section 173 within bracket 1 of MV Act 1988, read with Section 5 of the Limitation Act 1963 for condonation of delay of 206 days in filing the connected MAC appeal. Issue notice to the respondents.
Lordship, I have a humble submission, my lord. Respondent number 2 may be struck off, being the owner come rider.
No, you first take steps.
Because the appeal is for to the extent of enhancement only, lordship.
No, if he had to you had to make this prayer. Why you included him? You first take steps. If there is some difficulty, we'll see.
Lordship.
Issue notice to the respondents by speed post as well as by usual mode within 7 days from the date of this order. Returnable on 26th February, list accordingly.
Item 39.
This I is for condemnation of delay of only 5 days only. In preparing the second appeal, regular second.
Second appeal,
Yes.
notice will go. Heard Mr. A. Das,
N. Sharma.
N. Sharma, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been preferred by the applicants and by the applicant for condoning the delay of 5 days in preferring the connected regular second appeal, whereby the judgment and decree passed by the First Appellate Court on 6/9/2025 in title appeal number 47/2018 has been impugned. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of March.
Item 40,
My pleasure, lordship. Then I will lordship for condition of delay. 130 days is delay, lordship, in filing the revision.
Lord Mr. A. Diwan, learned counsel for the applicant. This application under section 5 of the Limitation Act 1963 has been filed for condonation of delay of 109 days in filing the connected revision petition, civil revision petition, whereby the applicant has impugned the order dated 31/5/2025 passed by learned Additional District Judge number 2, Nagaon, in Miss Guardianship case number 8/2023. Issue notice to the respondent. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of March.
item 44,
My lord, we have filed, my lord, IA, my lord, 3770, my lord, for paying for a, my lord, direction to the appellant insurance company for making 50%, my lord,
Pay is there?
already state appeal is admitted, my lord.
Pay is there or not?
No.
There is no stay.
How can he file?
Have you prayed for stay?
Lordship, first let's take this up because he has made certain allegation against me in that. Yeah. Whereas when the admission came, his name was not shown. I mentioned to the court that his name is not shown, and Lordship will peruse the order he has annexed, Lordship. Paragraph 5. She also requests that the name of Mr. A. Manna, learned counsel for respondent number 1, be reflected in the cause list. It was me who. And now let's look at his petition, Lordship.
No, what is the prayer? Prayer.
Prayer is that direction to the insurance company to deposit 70%. Where is the provision? Under what provision is this? Where is the provision that the claimant can file a petition like this before this honorable?
Prayer, my lord, what happened, my lord?
No, there is no stay application.
No.
There is
No, there is application. We have not taken any stay.
My lord, what happened, my lord? In the, my lord, appeal, my lord.
Are you pressing for stay application?
Lordship. No, Lordship, because Lordship will peruse paragraph 6 of his application. What he writes that it is further submitted that learned counsel for the appellant Miss R.D. Mujumdar was also silent towards the required deposit of 70% to be made before the registry of this honorable court. The said learned counsel for the appellant ought to have pointed out that the said issue before this honorable court at the time of admission. What is this kind of application?
My lord, may I pay, my lord? My lord, my submission before your lordship, my lord.
No, we'll take it up. We'll not consider this application now. We may take it up along with stay application if they pray. If they do not pray for stay application, this is infraction. This is not.
My lord, why I'm praying for by this application? My lord, what happened, my lord? They have also filed a condemnation petition. I appeared, my lord, in the condemnation petition. My lord, subsequently, at the time of admission of appeal, my lord, my name was not reflected. I could not make my prayer before the court, my lord. That's why this application has been filed, my lord. Praying for a simple prayer, my lord.
No, but they have not prayed for stay.
My lord, it is a normal practice, my lord. My normal practice, as and when.
Sometimes wrong practice need not to be followed.
My lord,
Unless there is a stay, where is the question of directing you to pay?
whether
You
the-
can go for full 100% before the executing court.
My lord, then, my lord, I pray before your lordship to withdraw my petition. My direction may be given.
Why direction? No direction. Award is in your favor. You can directly go to the executing court.
My lord, I am on presumption, my lord. They have filed, my lord, stay petition. That's why I have filed this application. My lord,
Oh, I am-
award is, my lord, very small award, my lord. 1,52,000, my lord.
Stay.
Well, out of this, my lord, I am paying for 50%.
You have filed a stay application. Are you pressing? Yeah,
I'm not pressing because
we can
because
dispose it off. We will,
that we are not pressing.
okay.
Lots of things.
Heard Miss R.D. Majumdar. IA 3320. 2025. Heard Miss R.D. Majumdar, learned counsel for the applicant, who submits that the insurance company is not pressing this instant application for stay.
At present, Lordship.
Not at present. This we will dispose it of.
Okay. LCR may be called, Lordship, and final hearing can be done because 2 and 3 we have striked out.
Okay.
They are appearing. Final hearing can be done. And that is my prayer in the stay also, Lordship. That since final hearing can be done of the case, and this is the LCR is from Kamrup.
She submits that since the connected MAC appeal may be heard finally, the insurance company is not inclined to press the instant stay application. This interlocutory application is accordingly disposed of on not being pressed. Stop. Next, all IA 3370. Heard Mr. A. Mannaf, learned counsel for the applicant. Also heard Ms. R.D. Majumdar, learned counsel for the respondent insurance company. This application has been filed by the applicant/claimant, praying for direction to the appellant insurance company to deposit 70% of the awarded amount before the registry. Stop. Stop. I have gone through the averments made in the instant interlocutory application. Since the insurance company has not pressed its interlocutory application, that is IA number 3320/2025, wherein a prayer for stay of execution of the impugned award and judgment was prayed for. And since the said interlocutory application is disposed of on not being pressed, there is no cause of action for the instant interlocutory application for directing the insurance company to pay 70% of the awarded amount. The petitioner, the applicant claimant may approach the executing court for execution of the impugned judgment and award. This interlocutory application is accordingly dismissed.
Lordship, in the admission, in the appeal, Lordship will take up. It was admitted the LCR was not called for inadvertently. So LCR may be called for.
Heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. A. Mannaf, learned counsel for respondent number 1. It appears that by order dated 29/10/2025, the names of respondent number 2 and 3 were struck off from the cause title of this appeal. Stop. Let the records of MAC case number 300/2020 be called for from the Motor Accident Claims Tribunal number 2, Kamrup Metro, registry to take steps for requisitioning the aforesaid records. Let this case be listed for hearing immediately after receipt of the aforesaid record.
First, let it come, Lordship, let it come for orders once, because otherwise if the record does not come,
Registry to list this matter after
2 weeks, Lordship,
2 weeks
because it is from Kamrup.
on receipt of the records of the MAC case.
Now I'm submitting something, Lordship. That day I did not press the stay petition just because he was not present. But his writing such kind of petition and writing against me, that's why I have not pressed.
My lord, that
Highly
is not
obliged,
correct, my lord.
Lordship.
That is not correct, my lord. He is, my lord, my, everything is, he is known person, my lord. He ought to have informed me, the case has come. Always, my lord, we are contacting. Sometimes I call, sometimes she call, my lord.
I don't call you.
Your
Highly
junior
obliged,
call,
Lord.
your junior call.
Item 45.
Yes.
May please, Your Lordship. It's
What is it?
for condoning a delay of 375 days.
Heard Mr. B. Kaushik, learned counsel for the applicant. This application under Section 5 of the Limitation Act has been preferred by the applicant for condonation of 318 days of delay in preferring the connected RERA appeal. Connected RERA appeal, whereby the judgment dated 13/11/2024 passed by the Real Estate Appellate Tribunal Assam in RET/Assam/appeal number 18/2024 has been impugned. Issue notice to the respondents. The applicant shall take steps for issuance of notice upon the respondent by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of March.
Grateful.
ঠিক আছে, বিজয়।
Yes.
May I please, Your Lordship. Lordship, the petitioner is the plaintiff, Your Lordship. The petitioner has filed a suit and the respondent defendant appeared and filed his WS. After filing of WS at the time of adducing evidence, the petitioner filed an application under Order 6 Rule 17 for amendment of plaint. That was rejected. Along with the amendment of plaint, they have also filed a plate for impediment, that is also rejected, Your Lordship. And impugned order, Lordship, starts from page 96. But operative portion, Your Lordship, will find as page 106. May I read, Your Lordship?
Yes.
paragraph 4, Your Lordship. There is no doubt to the fact that in the title suit corresponding to this miss case, already trial has commenced and the stage in the suit has reached adducing of evidence. Therefore, the nature of the amendment sought cannot be allowed when trial has begun. In such and such, the Honorable Guwahati High Court has opined clearly that post commencement of trial amendment cannot be allowed unless it is shown by the party seeking amendment that the issue would not be raised prior to commencement in spite of due diligence. Here in this case, the plaintiff states that it is rumored by Mukut Kolita that he has obtained a patta, and the plaintiff assumes that the patta was created by influencing the revenue authorities. Such a fact of rumor based on assumption cannot be a good ground to seek amendment. In fact, the circumstances as shows that there is absence of due diligence on the part of the plaintiff, as while issuing patta, the pattadars in land are always notified by the revenue authorities. The subsequent knowledge as shown by the plaintiff cannot be believed, that too at the stage of adducing evidence. Further, the amendment petition also speaks about impleadment of two persons as defendants, and those parties sought to be impleaded in the suit are lot mandals. It is pertinent to mention that the two persons acted in their official capacity, and if at all the parties are necessary to be impleaded, the plaintiff have to show reasonable ground and to seek impleadment of parties on the basis of necessary parties. There exist provisions under the CPC, and amendment is not an aspect to bring into records any parties in a suit. The ground that the plaintiff took that on the basis of the notice issued under Section 80 CPC, the revenue government officials did not respond against cancellation of patta issued to Mukut Kolita cannot be a ground to allow amendment, because not responding to any notice under Section 80 is not a criteria to believe the story speculated by the plaintiff. Further, in 2008, Volume 4 GLT 928 Boloram Pal, there are references of some cases, Your Lordship. It is opined in unison that after commencement of trial in a civil suit, amendment cannot be allowed. Basically, Lordship, on the ground, it was rejected that after commencement of trial, amendment cannot be allowed. That amendment part, and that impleadment part, Your Lordship, it is reflected that there is specific provisions, so that was rejected. There is no doubt to the fact that the proposed amendment sought by the plaintiff will bring a new cause of action, and it will constitute separate and different case altogether. Further, there is no doubt that the OP in the title suit will be prejudiced if at all such cause of action is brought anew. The prayer therefore cannot be allowed, as the very nature of the suit will change. Accordingly, the prayer made by the plaintiff stands rejected, Your Lordship.
Yes.
My amendment application, Your Lordship, it starts from page 59. My amendment application. Page 59, Your Lordship, Annexure 3.
Yes.
Actually, what happened, Your Lordship, after receiving summons, the respondent defendant appeared and filed his WS. From the WS, it has come to the plaintiff that
After receipt of summon in the aforesaid suit, uttering some objectionable words, defendant Mukul Kolita has rumored that he has got the patta cancelled by the ADC revenue by management through political circle, and being apprehensive the plaintiff has inquired in the office of the circle officer, Mongoldo Revenue Circle, and he comes to know that by order dated TRC 25/2020 dated 12/1/2021 of additional deputy commissioner and order dated 27/1/2021 of the circle officer managed Mongoldoi Revenue Circle, the periodic patta number 214 of village Kuarpara Moja Rongamati has been cancelled. The suit patta, your lordship, the name of the plaintiff was cancelled from the suit patta. Before filing of the suit was filed in the year 2020, last part, your lordship. And the order was passed during pendency of the suit, your lordship. So, showing ground that subsequently the plaintiff came to know about such a thing, and his name from the patta, that is the suit patta, is cancelled. So he prayed for some proposed amendment, which is reflected as page 66, your lordship. The amendment proposed by the petitioner plaintiff, your lordship, page 66. Proposed amendment. After paragraph 13, new paragraph 13A be added as follows. 13A, that after receipt of summon in the aforesaid suit uttering some objectionable words, Mukul Kolita has rumored that he has got the patta cancelled by ADC revenue by management through political circle, and being apprehensive, the plaintiff has inquired in the office of the circle officer, Mongoldo Revenue Circle, and he comes to know that by order dated such and such of the deputy commissioner and order dated such and such of the circle officer, Mongoldo Revenue Circle, the periodic patta number 214 of village Kuarpara, Moja Rongamati has been cancelled. Similarly, lordship, those are some statements regarding cancellation of patta, and your lordship, that is paragraph 13A, your lordship. And thereafter, lordship may come at page 73, your lordship. Page 73. The Secretary to the Government of Assam Revenue Department, Deputy Commissioner Dorong Mongoldoi, Additional Deputy Commissioner Revenue Dorong Mongoldoi, Circle Officer Mongoldoi Revenue Circle, Lat Mandal Sri Novo Kumar Nath and Lat Mandal Sri Joy Prakash Das be made party as defendant number 2, 3, 4, 5, 6 and 7 respectively in the suit. That new cause of action on
In order 6 rule 17 itself, you prayed for.
that is paid, your lordship, for implement. In application under order 7 order 6 rule 17, your lordship. That was rejected, observing that as there is a specific provision, your lordship. So that part rejected, your lordship. But this amendment portion, and there are 2 prayers also I prayed. The prayer, that in prayer portion following new prayers be added, that a declaratory decree be passed that order number such and such of additional deputy commissioner Dorong and order dated 27/1/21 of the circle officer Mongoldo Revenue Circle is illegal, null, void and without jurisdiction and liable to be cancelled. That a precept be issued directing official defendants to cancel the order dated 12/1/21 of additional deputy commissioner Dorong and order dated 27/1/21 of the Circle Officer, Mangaldoi Revenue Circle. Two prayers and pleadings, three statements, additional.
What was your original suit was
The
the,
original suit, your lordship will find at page 16.
what was this?
My
Claim.
suit for declaration, ejectment, recovery of possession, cancellation of agreement, issue of receipt and permanent injunction. And a specific prayer, your lordship will find at page 21, your lordship. In the prayer, your lordship, the order which were passed by the official respondents, that was not challenged, your lordship. No prayer was made. And so this amendment application, two prayers proposed, your lordship, proposed to be amended. And a specific prayer, your lordship, page 21, lordship will find that the suit of the plaintiff be decreed with cost against the defendant, that a declaratory decree be passed, that the plaintiff has got title, interest, and possession over the suit A land, that a further declaratory decree be passed, that the defendant has got no right, title, interest over any part of the schedule A land, and other prayers also. But this part, by which orders the name of the plaintiff was cancelled, your lordship, that was not challenged, your lordship. And the ground of the trial court was that at the stage of adducing evidence, trial has commenced, your lordship. On that ground, basically, that was rejected, and also observed that the petitioner did not have due diligence, your lordship. And in this regard, your lordship, the our High Court judgment, your lordship, 2009, volume 4 GLR 762. It is, lordship, that para, your lordship, it starts from paragraph 11, your lordship.
What you want to show?
Lordship, I would like to show that that at any stage of the proceeding, amendment can be allowed, and even there is no diligence that could be allowed, your lordship. It is reflected in para 11, 12, and 13, your lordship, of this judgment, your lordship.
We'll continue after lunch.
May I please, your lordship.
Yes.
Lordship, in the said judgment, your lordship, at paragraph 13, your lordship. Referring to the decision of the Apex Court in Salem Advocate Bar Association, it is submitted by the Learned Counsel for the petitioners, plaintiffs, that the object of introduction of the proviso to Order 6, Rule 17, being to prevent frivolous application which are filed to delay the trial. The present application filed by the petitioners, plaintiffs against the counterclaim ought to have been allowed, as it is necessary for deciding the real controversy between the parties effectively and completely. And when it was not found by the learned court below that such application has been filed to delay the trial. According to Mr. Mojumdar, the Supreme Court is in Usha Devi versus Rizwan Ahmed, AIR 2008 SC 4147 has allowed the prayer for amendment of the pleadings after commencement of trial, even though the petitioner plaintiffs therein were found to be not diligent in seeking amendment of the plaint on the ground that such an amendment was necessary for the purpose of bringing to the fore the real question of controversy between the parties. And thereafter, Lordship, at paragraph 20, well,
itu kalau mau balik penau, balik lagi. Yes, para.
and at paragraph 20, Your Lordship, the court observed, observation of the court. Paragraph 20, Lordship.
Yes.
It therefore transpires from the aforesaid decisions of the apex court that the prayer for amendment can be allowed at any stage of the proceeding, provided it is bona fide one and not filed with the object of causing delay in disposal of the suit. And when such amendment is required to decide the real controversy between the parties effectively and completely, and also when no serious injustice or irreparable loss is caused to the other side, which cannot be compensated by awarding cost. The proviso to Order 6, Rule 17 of the Code of Civil Procedure, however, provides that unless the court comes to a conclusion that in spite of due diligence, the party who is seeking the amendment of the pleadings could not have raised the matter before the commencement of trial, such amendment cannot be allowed. As observed by the apex court in Salem Bar Association, the object of the amendment of Order 6, Rule 17 of the Code of Civil Procedure, which to some extent curtails the absolute discretion of the court to allow amendment at any stage, is to prevent frivolous applications which are filed to delay the trial. Due diligence has not been defined in the Code of Civil Procedure. According to the Black's Law Dictionary, 8th edition, diligence means a continual effort to accomplish something, care, caution, the attention and care required from a person in a given situation. The meaning of due diligence as given in the Black's Law Dictionary is the diligence reasonably expected from and ordinarily exercised by a person who seeks to satisfy a legal requirement or to discharge obligation, which is also termed as reasonable diligence or common diligence. Due diligence, therefore, is such watchful caution and foresight as the circumstance of a particular case demands. The meaning of due diligence would therefore, for the purpose of Order 6, Rule 17 of the Code of Civil Procedure differs from case to case and has to be decided on the facts of a particular case. This is, Lordship, in respect of at any stage. There is another judgment, Your Lordship, I have given Your Lordship, that is 2026, Your Lordship.
What was your original suit for?
The original suit for ejectment declare,
Ejectment?
Lordship. Suit for declaration, ejectment, recovery of possession, cancellation of agreement, issue of precept and permanent injunction.
Cancellation of agreement.
Cancellation.
Why precept has to be, why prayer for issuance of precept was made?
Issuance of precept, Your Lordship, that is detailed in the prayer part. That is that a further declaratory decree be passed that the Chukti Patra, there was a Chukti Patra, number 4, date 179, dated 31/8/2020, is an illegal document. By such illegal document, defendant cannot acquire any right, title, interest over any part of the Schedule A land, and Chukti Patra number such and such is null, void, inoperative in law, and liable to be cancelled. That's Chukti Patra, Your Lordship. And in this amendment, our application is for, proposed amendment was for cancellation of the order, which, by which order my name was cancelled from my patta, the suit land, suit patta. That part is not there in the suit.
What was the real controversy in the original suit?
In the original suit, Your Lordship, their controversy was in respect of
By the amendment, your mutation was cancelled.
my patta was cancelled.
Patta was
Yeah,
cancelled.
that was proposed to be amended and included in the plaint.
Okay,
That part.
your first submission is that since the incident occurred after filing of the suit,
The order was passed after filing
of the suit, you could not have known about it. Second is, it is necessary for
necessary for real controversy between the parties. to decide
ascertain
the
the
real-
real control. Okay. Yes, what else?
And Lordship, in this regard, Lordship, that at any stage of the suit, there is another latest judgment of our High Court, Your Lordship.
At what stage suit is pending now?
Only for adducing of evidence of plaintiff. That was at that time. Plaintiff side has not filed evidence on affidavit.
You are the plaintiff.
Yes, Your Lordship.
Okay.
And Your Lordship, I would like to refer one judgment, Your Lordship. If this honorable court allows the amendment, in that case, Your Lordship, the other party will get chance to file his amended written statement to revert my claim, Your Lordship. That he will not be prejudiced in any manner. That is supported by a judgment to 2026, volume 1, GLR 504. I have supplied, Your Lordship. The journal, Your Lordship. The flag mark is there.
Additional WS.
That part, they will not, I like to submit that if this honorable court allows my amendment application, that the defendant will not be prejudiced. He will get the opportunity to file his additional written statement against my amendment.
What is the citation?
2026, volume 1, GLR 504. Lordship, it is the observation is start from page paragraph 34 of the judgment, Your Lordship. Page 511, paragraph 34. Here, the court observed that if such an amendment is allowed, it is specifically stated in paragraph 39, Lordship, paragraph 39. The authorities relied upon by the petitioner are on the principles of law regarding Order 6, Rule 17, CPC. Paragraph 39.
Yes, you read.
While agreeing with the principles, the facts are distinguishable in the present case. This court is of the view that the amendment allowed by the trial court in the present case does not change the character of the suit. No amendment is sought in the pleading, or no prejudice would be caused to the defendant petitioners, as all consequential steps such as amended written statements, filing additional evidence, or recalling witnesses are legally permissible to ensure fair trial. In fact, the amendment in the prayer portion will assist the court to decide the real question in controversy and allowing the multiplicity of proceeding. And the other judgment which I have submitted to your 2023 volume 3 judgment.
Okay. Yes.
The other judgment, Lordship, is 2023 volume 3 GLR 323. I have given the book, Your Lordship. In that judgment, Your Lordship, it was basing on the judgment by the Supreme Court in Life Insurance Corporation of India, paragraph 20, page 331. Upon hearing the learned counsel for the parties and upon perusal of the materials on record, this court would like to take note of a recent judgment of the Supreme Court in Life Insurance Corporation of India versus Sanjeev Builders Private and another, reported in 22 SSC Online, wherein the Supreme Court laid down the various parameters as regards the exercise of jurisdiction under Order 6, Rule 17 of the court. That in that judgment, Lordship, there is some categories are there reflected within which this honorable court can allow the amendment petition, Your Lordship. And lastly, Lordship, Supreme Court judgment is there regarding commencement of trial, Your Lordship. The AIR 2006 SCs I have given, Lordship. In paragraph
Rating
17,
of issues.
paragraph 17, Your Lordship, regarding commencement of trial,
What it says.
it says, Lordship, paragraph 70, before we part with this order, we may also notice that provision to Order 6, Rule 17 of the CPC provides that amendment of pleadings shall not be allowed when the trial of the suit has already commenced. For this reason, we have examined the records and find that, in fact, the trial has not yet commenced. It appears from the records that the parties have yet to file their documentary evidence in the suit. From the record, it also appears that the suit was on the verge of conclusion as found by the High Court and the trial court. That apart, commencement of trial as used in proviso to Order 6, Rule 17 in the Code of Civil Procedure must be understood in the limited sense as meaning the final hearing of the suit, examination of witnesses, filing of documents, and addressing of arguments. As noted hereinafter, the parties are yet to file their documents. We do not find any reason to reject the application for
When
amendment.
trial is said to have commenced?
Lordship.
When?
As per the judgment,
The judgment speaks about many things.
Lordship,
Therefore, I'm asking when we
Lordship,
can say that trial has commenced.
trial has commenced, we can say from when the date is fixed for filing of evidence, Your Lordship. Order 18 rule. Evidence, from evidence, but in this case, I have not submitted my affidavit evidence, Lordship. At that stage, application was filed. If Your Lordship allows this petition, the respondent will definitely get to file his additional written statement, Your Lordship. And he will not be prejudiced. And there is no reason to delay as because this is my suit, Your Lordship. My humble submission, that is, my petition may be allowed.
Yes, Mr. Majumdar.
The trial begins from the date the issues are framed.
Issues.
Supreme Court is very clear on that. And as your lordship is aware, madam, for framing of issues, a hearing takes place. It is another thing that in many cases, both the parties know their cases, or on a trial court also knows, so it is very informally framed. But then otherwise, for
Issue
framing
hearing.
in contested matters, for framing issue also,
Yes.
a hearing takes place. The lordship is aware of that. And in this case, normally an amendment sought in respect of the prior portion, addition of parties is not opposed. And there is no question of opposing because we get an opportunity to file a written statement.
Yes.
But here the case is slightly different, my lord. If your lordship kindly go, I'll just indicate, my lord, because it's a very voluminous written statement. What has happened in this case, my lord? The land was actually ceiling surplus land. And your lordship is aware under the Sealing Act, once the land is found to be in excess of the ceiling prescribed by the Act, it becomes a Sarkari land. After that, for settlement of this Sarkari land, government land, initially abonton in Assamese manner in our vernacular, otherwise it's allotment.
Allotment.
Fine. So it is initially allotted at that time, no premium is taken. But subsequently, when the actual settlement takes place, then premium is taken, then he gets title. Before that, it is only an allotment. In this case, the land belonged to one Haricharan Deka. When the plaintiff was in possession of the land, it is there in detail in written statement. I'll come to that. That's just specific areas. I'm just one way. Otherwise, it's a very huge one. I wanted to read some of the paragraphs of the written statement.
Okay, no, you tell me the gist.
Yes, ma'am. It starts from page 27, and it runs up to the 57, 30 pages. So I don't want to waste court's time. I'm
Yes.
giving the relevant portion. Initially, it was a ceiling surplus land belonging to one Haricharan Deka. From Haricharan Deka, this plaintiff came into the possession. Haricharan Deka was issueless. At that time, it was allotted land only. At that stage, he, by executing an unregistered deed, 3 unregistered deeds, he took 15 lakhs from me, from the defendant, and sold 3 plots of land. Altogether, it comes to 4 kathas. And then he promised that once it is converted into periodic patta, he will execute a registered sale deed, because at that time he didn't have the saleable right to execute the sale deed. Yes. Then, my lord, I came into possession of the land in 2011. These unregistered agreements were, sale deeds were executed in 2011. I came into possession. I'm a school teacher, my lord, very humble man, and I'm residing there with my wife. And what kind of man the plaintiff is, I'll read from the defendant, not my personal knowledge, from the written statement. Now, he resides there from 2011. Subsequently, this gentleman plaintiff, he got the entire land of 3 bighas and odd settled in his name. Very well. Now, thereafter, he's supposed to execute the registered sale in my favor. Now he says no. Not only that, he executes this kind of agreement with one Mr. Ajay Barua, who are different type of man, my lord. They come in the midnight to attack me with daw, etc., and I have to lodge a FIR because I'm a school teacher. I cannot fight. It's from the written statement, my lord. It is there from the pleading. I'm not saying from verbal instruction. Now, when he refuses to execute the sale deed after the settlement in respect of the entire land was given in his name, although I was in possession, and under the settlement rules and the Assam Land and Revenue Regulation, your lordship is aware, a person who is in possession of the land will be settled with the land. He was not in possession because by the time the settlement operation started for a settlement of the land, I was in possession because there was an unregistered sale deed, and he took 15 lakhs from me. And this he admitted in the proceeding. I am coming to that, my lord. Thereafter, I lodged a complaint. I had to run from pillar to post. To Dispur, I had to catch hold of many officers, secretary, minister. They kindly do something. This is the position. Then a process was started from the government level, my lord, about how the land was settled. And a case was registered. And in that case, he got an opportunity to object. Unfortunately, this everything started before the institution of the suit. The suit was filed, my lord, on 22nd of December 2020. And after I raised objection, after giving him an opportunity of hearing, and he filed written objection, admitting that he actually executed a registered, unregistered document to transfer the land to me with a commitment that he will execute it. All these things he has admitted before the authority, who gave him an opportunity of hearing. And after giving him an opportunity of hearing, the patta was cancelled on 2/9/2020, much before institution of the suit.
Okay.
And he gave a date of 27/1/2021. Lord, will kindly note the date. He gave an application, fact of knowledge of cancellation dated 27/1/2021, so as to file the amendment petition now. The reason is, my lord, it was cancelled in 2020. Process started from 2/9/2019. I filed the objection.
2/9, it was cancelled.
No, my lord, it was cancelled. Yes, it was cancelled on 2/9/2020. Before that, I raised my objection.
On 17/8/20, he filed his written objection.
And he filed his written objection before the authority, my lord, which your lordship will find at page 39 of his revision petition. 17 August 2020, he filed a written objection. That is also before the institution of the suit. All these things are suppressed in the plaint, and the suit was filed. I don't know what advice he was given. Suit was filed after the cancellation of the patta in his name. He filed the suit only against the defendant, praying for a declaration of decree of declaration of title. He knows that it is already cancelled. It was only for the purpose of making it online that 27/1/2021 was the date. Otherwise, cancellation was prior to institution of the suit on 2/9/2020. All these things were suppressed in the plaint, and a suit for declaration of title simpliciter was filed before the trial court, because possibly the plaintiff.
You raised this objection before the trial court while opposing the amendment.
I have filed the written statement stating all these things, my lord.
Okay, okay.
Written objection is also there. I am speaking from the written
Objection
statement.
against Order 6, Rule 17.
My lord, my lord.
Okay.
And once, my lord, I file the written statement, my pleading remains. Whatever objection I have raised in the written statement also can be considered. All these things in detail, my lord, it is in two details. That is why I am not reading. Few lines from page 39 first, my lord, will kindly see. W starts from page 26 and page 39, Lord, will kindly see.
Yes.
No, I'm sorry, man, page 37. Page 37. As your lordship got it.
Yes.
The real facts, my lord. The plaintiff has suppressed material facts from this honorable court. The defendant begs to state that plaintiff and his brother, namely Hemanto Deka, after the death of Haricharan Deka, transferred land measuring 4 kata to the defendant by way of unregistered sale deed while the land was Abanton Patta land. Subsequently, the plaintiff, without the knowledge of the defendant, suppressing the fact that he and his brother, namely Hemanto Deka, transferred by way of unregistered sale deed of land measuring 4 kata to the defendant, converted Sarkari Deg number so-and-so measuring 3 bigha 1 kata 12, say entire land, into period patta being so-and-so, so-and-so, so by Deputy Commissioner Tarang dated 28/11/2019 in Abandoned Settlement case number so-and-so. Thereafter, plaintiff again by suppressing the fact that he and his brother, namely Hemanto Deka, transferred by way of unregistered sale deed of land measuring 4 kata to defendant, mutated the name of the plaintiff in place of Haricharan Deka in Jamabandi so on 4/12/2019 in respect of the land measuring 3 biga 1 kata 12 meter without the knowledge of the defendant. Thereafter, defendant came to know from this reliable source about conversion of Avantran Patta land measuring about 3 biga 1 kata 12 meter into Pidik Patta, and after coming to know about it, the defendant filed a petition on 24/6/2020 before the circle officer Mangaldoyi Revenue Circle stating that he has been in possession of 4 kata of land by constructing his house out of total land measuring 3 biga 1 kata 12, but wrongly at the time of conversion into Pidik Patta, his name has not been inserted in the aforesaid dag of land measuring 4 kata. Prior to conversion into Pidik Patta, he purchased the same. Without the above statements made in the petition, he prays for inclusion of his name, etc. My lord. Now we can skip this, my lord. Then you'll also kindly come to right hand side, page 39. Somewhere in the middle, my lord, you'll find thereafter. The circle officer Mangaldoyi Revenue Circle has again issued notice to the plaintiff, white number so and so dated 14/8/2020. This is before the institution of the suit, to appear before him on so and so, and circle officer Mangaldoyi Circle by so and so observed that he has received letter by memo number so and so issued to him by the ADC Darang Revenue the Mangaldoyi. Detail of the letter herein after mentioned by his office order of so and so directed to make an inquiry to Lat Mandal regarding the cancellation of Pidik Patta in respect of the schedule of land describing the plain due to transfer of the land and to submit reports in this regard. The defendant begs to state that plaintiff filed his written objection on 17/8/2020 supported by an affidavit in Miss Case number so and so alleging that defendant has no registered sale deed and as such he could not get mutation in the patta, etc. So he has filed an objection before the authority. Now, Lordship will kindly come to page 46, my lord. Page 46, line about 5th from top, my lord.
Yes.
Thereafter, Lordship is government, thereafter, after the date.
Yes.
Thereafter, as already stated herein above, Circle Officer Mangaldoyi Revenue Circle, after receiving the letter being so and so from the ADC, again made an inquiry into the disputed land through one Jayaprakash Das Lat Mandal. As already stated above, the Lat Mandal visited the disputed land and made an inquiry and found that prior to conversion of Pidik Patta, land measuring 4 kata has been transferred and aforesaid land has been under possession of the defendant number 10 since 10 years by constructing his house and basti. Due to transfer of the aforesaid land, the terms and Pidik Patta land has been violated. Therefore, it is for the consideration of the Circle Officer Mangaldoyi for cancellation of the Pidik Patta. Moreover, as already stated that the Circle Officer Mangaldoyi Revenue Circle order dated 2/9/2020 cancelled the Pidik Patta issued in favor of the plaintiff. Before instructions, well, I will not read the written statement further unnecessarily, but I will show only one thing from page 50, my lord. Page 50, my lord. My lord, somewhere in the left-hand side, my lord, maybe 8-9 lines. By dag number 202, Lordship has got, my lord. Page 50.
By dag number?
802.
Yes.
After next line, thereafter, my lord. In this way, after cancelling the Pidik Patta in online land record system, Dharitri, and after converting Pidik Patta bearing number so into government land with dag number so the Circle Office Mangaldoyi Circle issued a letter by so dated 22/4/2021, submitted above report for kind consideration and necessary action to the ADC. In this way, the Pidik Patta issued in favor of Noreshwar Deka plaintiff was cancelled prior to filing of this suit. White order dated 2/9/2020 passed by the Circle Officer Mangaldoyi Revenue Circle and subsequently cancelled on online Dharitri as already stated above. The land was again converted to government land covered by dag number so on inquiry found 4 kata of land in possession of the Mukul Kalitam. There is the defendant, my lord. So this is the background. Now, my lord, two things are there. Just I'll show one thing before I make my submission. Page 55, Lordship may kindly turn, my lord. Page 55.
Yes.
It starts from page 54, last line. my lord. On failure, threatened to kill him, they also removed the boundary fencing of the defendant in the night, taking advantage of absence of the defendant in his house. To this effect, on 12/8/2020, defendant as informant lodged an AJR before the OC Mangaldev police station. Thereafter, on 19/9/2020 at about 12 a.m., the plaintiff, along with his wife, son, and some miscreants, being armed with dao, kuthar, jatti, jong, etc., again attacked the defendant and his family and tried to kill him. To this effect, an AJR has been lodged, an AJR before the officer in charge, Mangaldev police station, but the AJR has not been registered. So this is the background. I just wanted to show, my lord, the facts based on which the present amendment is sought, where in the knowledge of the plaintiff, but he suppressed all these facts and filed a suit for declaration of title only against defendant, whereas he himself did not have any title over the land because the patta has been cancelled. Now, on the prayer for amendment, my lord, there are two basic reasons on which the application has been cancelled. One is this amendment, if allowed, changes the nature and character of the suit. And the second is, my lord, due diligence. First, I am dealing with the nature and character. My lord, the suit is filed for declaration of title against me. Now, if you subsequently show that you do not have title, your dispute is no longer with me. Your dispute is with the state because they have cancelled. And therefore, by issuing HTCPC notice, you are now trying to bring in state, circle officer, mandal, ADC, etc. So unless your first grievance against the state is resolved and it is found that you have title, the question of filing second suit against me doesn't arise, because if you do not have title, there is no question of getting a decree for declaration of title as against me, my lord. Now you are in the same suit, you cannot pray for it. It's completely different cause of action and completely different suit, my lord. That being the position, my lord, it is very clear that if this amendment is allowed, this will definitely change the nature and character of the suit. Now this will be a suit against the government as to how, why, and on what basis the patta has been cancelled. And in that dispute, I have got no role except for the complaint that I made. You will have to establish that you are entitled to the settlement and cancellation was improper. There is a dispute between him and the state that has got no connection with the present suit, where you are praying for a decree of declaration of title as against me only. And now Lordship was asking a very pertinent question, then why then, on what basis or based on what cause of action you filed the original suit? When he filed the suit, my lord, he says that there was an agreement by virtue of which I allowed you to stay there by constructing a house and you will pay me rent.
So,
but
for cancellation of that agreement,
my lord, for cancellation of
that agreement.
No, he says that now I am trying to grab the property by asking for mutation, etc. before the authority. And that is why he wanted a declaration of title and my eviction. He projected me as a tenant now in the suit. He is aware of the whole story that I have proposed the authority for cancellation. And ultimately, after giving an opportunity of hearing, the patta was cancelled. Even then, and in the written objection, he admits that yes, by an agreement, he transferred the possessory right to me. All these things I have stated in detail in the written statement. But suppressing all these facts, he has filed the suit for declaration of title against me only. And now it is very clear that cancellation has taken place before the suit was instituted. And you took part in that. At least you should have disclosed all these things. And because if he discloses all these things in the plaint, there will he will be left with no cause of action as against the defendant, private party. That is why he suppressed and tried. So there is first part, my lord, that it will definitely change the nature and character of the suit. And the learned trial court has clearly held in paragraph 8 of the judgment at page 107 that it will change the nature and character of this suit. Page 107, my lord. Page 107, paragraph 8 at the bottom, my lord. There is no doubt to the fact that proposed amendment sought by the plaintiff will bring a new cause of action and it will constitute separate and different case altogether. Further, there is no doubt that the OP in the title suit will be prejudiced if at all such cause of action is brought anew. The prayer therefore cannot be allowed as the very nature of the suit will change. As regards the due diligence part, my lord, your lordship is aware, earlier, before the amendment of the CPC, there was no requirement. But in the year 2002, when the Civil Procedure Code was amended, a proviso was added that after the trial begins, amendment cannot be allowed unless you show that in spite of exercise of due diligence, you could not introduce or you could not pray for the amendment. Now, for this, in order to cover this or meet this need, my lord, under the law, he says that I floated a rumor that there has been a cancellation of land. Then he made an inquiry, then he found that it was cancelled. But you participated in the process. If you participated, you were aware. So the whole story narrated in the amendment application to justify that he was diligent is actually based on false story, my lord. Suppression of fact. And my lord, there's one judgment which I'll cite, my lord, which says that it's not a matter of amendment, is not a matter of right. Here, my lord, in this case, this paragraph 2, your lordship will find the initially a suit for partition was filed. Paragraph 2, well, I'll not read it. This was a case where initially a partition suit was filed and subsequently an amendment was sought to challenge or for a declaration that earlier compromise decree is bad in law. It is in this background, my lord, initially the trial court, my lord, dismissed. The Honorable High Court of Karnataka, I think, allowed the prayer. Then the matter went up to Honorable Supreme Court. Supreme Court allowed the appeal and rejected the amendment, my lord. Just paragraph 12, I'll read. The principle has been laid down in paragraph 12. Actually, the original judgment is of M. Revanna versus Anjanamma. Relying on that, my lord, this has been held in paragraph 12. Lordship has got paragraph 12. This court in M. Revanna versus Anjanamma opined that an application for amendment may be rejected if it seeks to introduce totally different, new and inconsistent case or changes the fundamental character of the suit, as in our case, my lord. Order 6, Rule 17 prevents an application for amendment after the trial has commenced unless the court comes to the conclusion that despite due diligence, the party could not have raised the issue. And in our case, there is hardly any question of due diligence. Before the institution of the suit, you were aware of it. You have suppressed it. Not a case where, in spite of due diligence, you could not discover some fact which you want to introduce after by making an amendment. You were aware of all these things. You were silent in the plaint, deliberately.
Yes.
The next line says, my lord, the burden is on the party seeking amendment after commencement of trial to show that in spite of due diligence, such amendment could not be sought earlier. It is not a matter of right. Then paragraph 13, Lordship will kindly see for a moment, my lord. Initially, the suit was filed for partition and separate possession. By way of amendment, relief of declaration of compromise decree being null and void was also sought. the same would certainly change the nature of the suit, which may be impermissible. Now, the next paragraph says, my lord, this court in so-and-so enumerated the factors to be taken into consideration by the court while dealing with an application for amendment. One of the important factors is as to whether the amendment would cause prejudice to the other side, or it fundamentally changes the nature and character of the case, or a fresh suit on the amended claim would be barred. That's a different thing, matter. We are not concerned with. Then paragraph 18 says, when this SLP was allowed, the impugned order passed by the High Court is set aside with a cost of 1 lakh. And the present respondent, who is the defendant, he is harassed like anything. My learned friend was told, I have instruction from my learned friend, that he comes and says, I am harassed like anything because he has same land. He has taken 15 lakhs from me by executing an unregistered document. Say, part of that land he has sold to one Mr. Ajay Barua. And those are, my lord, slightly different type of men. They regularly harass me. And I have to approach the police authority. They also don't take any action. This is my position, my lord. And I'm a school teacher. I leave it to your lordship, and lordship will kindly reject the petition and affirm the order passed by the learned trial court.
Heard. Mr.
Yeah, sure.
This is item number
11.
11.
11. Heard Mr. A.R. Shom, learned counsel for the petitioner. Chamber meeting. Also heard Mr. D. Majumdar, learned senior counsel, assisted by Mr. D. Majumdar, learned counsel for the respondent. I am reserving the judgment.
Lordship.
Hearing concluded, judgment reserved.
Deeply.
First page to photocopy করবো এই cited কিতাবৰ যিটো judgment cite কৰিছে সেইটো photocopy.
I take.
Yes. This is your book.
Lordship.
Photocopy করে return করে দিন.
Item 31.
Yes.
My lord, on last, as per last order.
Service report is still awaited upon respondent number 4 to 7. We have taken steps as per the order dated 9/4/25. But
You have taken steps.
we have taken steps. But those
But
still
the
are not
office
taken.
note says that
Office note reflects that fresh steps were taken, but Dosti was not taken. Steps were taken by registered post with AD and usual process. The order though allowed us, but it was not a direction made. So
No, no.
it is not.
office note says that you have not at all taken steps by any mode. If you have not taken steps, then your CRP is liable to be dismissed.
I instructed my clerk and he reported back to me that it is taken.
What is there to show? When you take steps, you get an acknowledgement.
Yes. It is also submitted there.
Is there anything to show?
Exactly, my lord.
What is to be done? Okay.
If it is not taken, my lord, it is my responsibility, even though my clerk did that, but I beg to give some time. Will take.
Heard, Mr. What is your name?
All the
all Oscar, learned counsel for the. Is there any stay?
No, my lord.
No, no
Okay,
stay now.
okay. Also heard Mr. What
L
is
Deca on behalf of M. Datta.
L. Deka appearing on behalf of M. Datta, learned counsel for respondent number
1 and 2.
1, 2, 3.
1, 2, 3.
1, 2, 3. On perusal of the office note dated 27/1/2026, it appears that the petitioner has not yet taken any steps for issuance of notice upon the respondent number 427. Staff learned counsel for the petitioner submits that he had instructed his clerk to take steps and he was reported that steps was taken. However, he submits that in light of the office note, he may be granted one more chance to take fresh steps on the aforesaid respondents. The prayer is allowed. The petitioner shall take fresh steps for issuance of notice by speed post as well as by usual mode. Issuance of notice on respondent number 427 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 2nd of March. The petitioner may additionally take steps through by way of dusty mode also. In the event he is able to serve the notice on the aforesaid respondent by dusty mode, he shall file an affidavit of compliance to that effect on the next date fixed. Let this matter be listed on 2nd of March.
29.
Last matter.
May I please the lordship? In this case, I have received the copy from my learned friend. I just need some time to obtain the necessary instruction.
Okay.
Actually, we have submitted that copy in the office of Apodi FGI.
Okay, now he has heard Mr. S.Z.B. Aklas, learned counsel for the appellant. Also heard Mr. S.P. Chaudhary,
For the railways lordship.
appearing for, so yours.
Standing counsel railways.
Standing counsel railways, appearing for respondent. Who seeks some time to take instructions
Exactly.
in this regard. The prayer is allowed. Let this matter be listed on 13th.
More time, lordship, at least 3 weeks time may be given.
My lord, actually serious illness condition
And after 2 weeks, any date after 2 weeks.
13th February,
Article.
large day also absent, my lord.
13th of February.